Good morning and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us as we pick back up on day 6 of Iowa versus Todd Mullis and his post-conviction relief hearing. How are you guys doing today? Make sure you hit the like button as you come in. I will follow my own advice and do the same. How are we doing today? Drunky the Bear, you had an earthquake. How are you guys doing? I know I asked. I'm not sure if you replied. Hey, Krista Limited Edition. Good to see you. Julie, good morning to you. Florida PI Sam, hello, hello. Therapist You Know, good morning. Only Fan, how are you doing? Baka, Fala, Marley Mum, good to see you. Queen Olive, Ruth Ann, Irish Amy, hello to you. Oh, Irish Amy saying hello to everybody. Good morning to you. Julie BME, thank you. How are you? How was your guys' weekends? We were working. Brett, good to see you. Thank you for joining us. Hope you had a good weekend. I know you were doing some serious yard work. MEG, first in the chat. You win the internet, as it goes. Carol O'Neill, Willow Johnson, hola, good morning to you. Thank you for joining us. Yeah, we streamed Saturday and Sunday. We're trying to catch up on Monica Sementili. Erica Hubner, good morning to you. Hey, Jim Reagan. Did I say your last name right? Reagan or Reagan? Thanks for joining us. You're new in the chat. Appreciate you joining us today. Joanne Jedi Platypus. Good morning to you. I think I still owe you a Kel walk. I think I still owe you a Kel walk. All right, so let's see. Day 5, Todd Mullis. We have some band names for Mr. Mullis, as we always do. Tensile Overload, Psycho Smiley Eyes, and Giggle and Whisper. Although Giggle and Whisper sounds more like a bar. The Giggle and Whisper. I'll meet you down at the Giggle and Whisper. Oh, so you know what Aaron and I were talking about over the weekend? What do you guys think about this? The one person that put Todd in prison is, wait for it, drum roll, Tristan. And the one person that can get Todd out of prison, wait for it, drum roll, Tristan. Right? If Tristan had testified during the trial that he never saw his dad leave, his dad was always in his eyesight, you know, he may have gotten a drink, but it was for like 2 seconds, then there's just no way that Todd could have done what he did. Nope, I hope everybody's okay. Ambulance just drove by. Yeah, so if Tristan had testified during the trial that there was no, Todd was never out of his eyesight for a long time, you know, maybe a minute here, a minute there, then there's his alibi. He never would have been, there wasn't enough time for him to sprint 150 yards, do what he did to Amy, and then sprint back. It just wouldn't have happened. So now what happens if Tristan goes on the stand now, because he's clearly for his dad. He's there, he's got his cross, he's smiling at his dad, he's waving at his dad's looking back at him. So what if he goes on the stand now and says, all right, my deposition was like a minute 45 seconds, meaning that was the time frame that Todd had, you know, was out of his eyesight. Then during the trial, he said maybe 5 minutes, 10 minutes, I don't even remember. I think it was an undetermined amount of time. What if he goes on the stand now and says, look, you know, I was 13 then, you know, I don't know what I was saying. Here I am, I'm 18. I know exactly what I saw. Dad didn't leave my eyesight for more than 30 seconds to a minute. Right? What do you think about that, guys? Marley Mom used to have a blind Yorkie named Mickey Mouse, or Mickey Moose. Hey, Yorkie, thanks for joining us. Shirley Roth, why did Tristan change his testimony? That's a very good question. That's a very good question. Why did he? I don't think we really knew. No, Shirley Roth, Mitten says hello to Super Ball. She's actually not with me right now. She's over in the on the couch. She's like wrapped up. Mel Stiller, you had a 4.4 earthquake. Wow. Oh, southern Vancouver. Wow. And Drunky the Bear, you felt it too. That's pretty big. Hola. I think you and Aaron may be right. Who's the one that theoretically put Todd in prison? Was Tristan's testimony. So if he had said, no, my dad was only out of sight for 30 seconds, a minute tops, Hey, Trial Junkies United, how are you? Good to see you. Christy G came in to say hello and give a like. Thank you. Appreciate that. Debbie Blair, good morning to you. Thank you for joining us. Always good to see you in our chat. Florida PI Sam, care to adopt a high-maintenance gray cat with air furnishings to join the family? Thanks, but no. We have our hands full with the three of them. It's expensive feeding these little guys because we feed them raw meat, and it's expensive. It gets expensive. Irish Amy, well, there's actual blue sky and sun here, so I'm hoping it was a sign. Nice, yeah. We've had a stretch of weather. The weekend was gorgeous. It was like 70, 73 or 4 yesterday. Nights, it was like 45 this morning. Baca, can we rewatch Tristan's testimony? I'll try and figure that out because we're trying to catch up on Monica Cementilli too. So maybe during lunch. Maybe we can do that during lunch. Shirley Roth, never change your testimony. Just say can't recall. Yeah, Tristan testified off camera. I don't know, was he there? Yeah, he was there. I think he was there. I don't think he zoomed it in or whatever. I think he was there, but he wasn't on camera because he was 13. They didn't have him on camera. Yeah, we could rewatch it. I just don't want to rewatch it afterwards because we're trying to catch up on Monica, so I don't want to eat into that time. But let's see. OnlyFan asked, does anyone remember if Tristan stayed with Todd's in-laws? You mean after all of this happened? I'm not sure. Hey, Sherry. Good morning to you. I still wanted to find when the defense attorney, the prosecutor played, go to hell, you cheating whore on the 911, which I did not hear. I didn't hear it the first time. I didn't hear it the second time. I didn't hear the third time either. So whenever squeegee, okay, Baca. Yeah, we'll try and get it in there. Marley Mom, Madonna yesterday was spicy. Yeah, she was. She was a spicy. Yeah, it was definitely spicy. All right. Let me get to Todd. Pull up. Let's see. His description over here. All right. Just to have that handy. Tristan was the third to testify. Trying to see if I thought I wrote it down. I know I wrote it down. How long Todd was out of sight. So loses sight of Dad, doesn't know for how long. But in the deposition, he said Dad was out of sight approximately 1 minute and 45 seconds. So that's cutting it pretty close too. And he never once said Dad was red-faced or sweating or out of breath because, again, 150 yards, stabs Amy, then runs back in under 2 minutes. You would think Todd would be like huffing and puffing. Hey, Hellcat, how are you? Marley Mom, is this the last day for Todd? We have no idea. OnlyFan says, I think that is why he was pressured to change his testimony. Could have been. Hey, Pammy. Good morning to you. Hope you're doing well. Yeah, Marley Mum, I'm not sure. It's probably going to go all week, I would think, because we still have the state needs to put on their case. Yeah, Shirley. Yep. Still don't know how Court TV, what they said, got into that trial. It is ridiculous. Yep. I agree. Brenda Mayer, good morning to you. Thank you for joining us. Day 6 of Todd Mullis post-conviction relief hearing. Do make sure you hit the like button. Please and thank you. Super Ball will appreciate it. Super Ball will appreciate any and all likes. Hola. Oh, we have court. Hold on. Let's let me get you into court. Sorry, Hola. Wait, hold on. All right. Thing is, we would really trust a 13-year-old's estimation of time as being a reasonable doubt. Maybe the jury discarded it. Possibly. Good point. All right. We have court. Let me get us in there. Oh, for crying out loud. Ugh. Okay. There we go. All right. See you guys on the other side. All right. Seems like they're taking some time. Marley Mum, may I ask what happened with Court TV? Yes, well, we heard in testimony, I think it was Friday, that either Thursday or Friday, the prosecutor played that 911 call, and somebody that was watching Court TV on YouTube called in and said, I think Todd said, go to hell, you cheating whore, die, you cheating whore, whatever he said, something along those lines, which was pretty terrible. And then the prosecutor ran with that, and they made a transcript and they played it, and they said the first time they played it, they didn't say anything. Then somebody watched it that was watching Court TV. Then they called in and said that's what Todd said, and then they played that. I think maybe it was during her closing. I was trying to find it the other day. Maybe it was during her closing, and that's highly prejudicial. I mean, it's like beyond prejudicial. And he didn't say it. We listened to it the other day. He didn't say that. He's like, I think the worst he said was, come on. He's like doing these compressions, CPR, these chest compressions, and he's like, come on, trying to will her back to life. He was out of breath. He sounded distressed. So that's what happened. Mel Stiller, considering the courtroom attendance, I don't think Todd has many fans. He's got pretty sure he's got a Facebook page and also I think a website, Justice for Todd or something along those lines. Therapist, I can't believe they used that as evidence in a criminal trial. Yeah, I know. It was highly prejudicial. Marley Mum, that's how it all started. Not cool. Yep. Follow that. Seriously, how they came up with that? That is seriously how they came up with that. Let me find the actual testimony. Prosecutor told him someone watched on Court TV called in about the muttering under breath. And that came in from Firehelm. That came in from him. And that was day 5. That was, I guess, we heard that on day 5. Or did we? Yeah. Yep. Can you imagine? Irish Amy, that is wild to me that they allowed that in. I agree. Marley Mom, that's kind of like when Robert Tellis mentioned a comment from Twitter who said he had different rims. Yeah. Father, I either didn't catch that or forgot when I watched it originally live. We didn't know until just now, or until Friday. We didn't know that was in. I mean, we thought the prosecutor came up with that. We didn't realize at that point in time. Leslie says, while we were waiting, why do you feed the kitties raw meat? Just curious. We started feeding our dogs. We had 2 Jack Russells, and we switched over from kibble and soft food to raw meat after watching Karen Becker. When was that? Maybe 2015 or 16. And she talked about a species-appropriate diet. And the more we researched, the more we looked at it, it just made sense to us that dogs should not be eating processed anything. So we just went with raw. And we figured and then the feral cat, meaning Super Ball, we fed her straight away meat, and she's never had anything but meat. And then our 2 ferals now, they've had nothing but meat. So we're like, we always go back to what would these animals be doing in the wild? They wouldn't be eating processed kibble. They wouldn't be eating manufactured food unless they're in a garbage. I get it. Dogs could eat garbage, sure. So we just go with the raw meat for them. Father, it is amazingly healthy for them. It's pricey. It does get pricey. I have a shame. Please no one use my comments as evidence in court. I know nothing. Hey, Michelle Phillips in NC, how are you? I didn't like that attorney. He doesn't seem too bothered that Todd was found guilty, whether it is or not. It was the female. It was the female attorney. There were two. Yeah, there was John Bernau. He was the attorney. Then Denise Timmons. Denise Timmons was the blonde. She's the one that delivered the closing argument. So yeah, and John Bernau. We'll go with that pronunciation. We also found out that Amy's affair was with a deputy or sheriff. You know, that's the first time we heard that. We know she had an affair. They told us that she had a previous affair and that Todd and her had worked it out. But that's the first time we heard in this post-conviction relief hearing that it was with a deputy or a sheriff. I forget. Raleigh was his name. I'm not sure if he was a deputy or he was a deputy for sure. I'm not sure if he was a sheriff at that point in time. So that's the first time we heard that. Debbie Gibby, have we seen the sheriff? We heard from Travis Hemeseth. He was a deputy at the time. He's the one that did the whole UTC code, and he messed that up. So he's a sheriff now. We haven't heard from that sheriff/deputy. No, we haven't heard from him yet. Follow. Meanwhile, your terrorist is chewing on a rock. Yeah. Gordon, oh no, not raw meat. Yep, that's what we do. We give them raw. We feed them raw. All right, Drunky the Bear, see you in a little bit. We will be here. We'll be here all day. Debbie Gibby, I think she had a few affairs and he was flipping mad like most husbands would be. Apparently they worked it out. And then the second time with, the second that we know of, yeah, there could have been more, but the second that we know of was with Jerry Frazier. And Todd confronted Jerry. And Jerry said, by all accounts, Todd was cool. It wasn't like he was like, he wasn't screaming, yelling at him, come to his house with a gun. You know, I think he called him up. He called his wife. I think he even apologized to them. He apologized to his wife, you know. Oh, wow. What's that? Yeah, he apologized afterwards. So, you know, Todd doesn't come across as this, you know, ogre that they were making him out to be. So... Yeah, Marley Mum, your rescue puddles likes to eat poop. Yeah, our dogs would eat the cat poop. We had we were taking care of Aaron's grandmother for a little while there, and she brought her little dog Dexter. He was a little Cairn Terrier. He looked like Toto. Basically, he was Toto, and he would go around because we had a bunch of feral cats living, and we tried to chase him away at that time, and he would eat the cat poop. And it was just disgusting. And Iggy sometimes would eat cat poop too. Not a lot, but he would get it like maybe once every other month or so. And I guess, you know, the research that we did, it's like they're looking for, there's something that's not in their diets. You know, you have to get, it's like nutrients, I guess, they're trying to find. So, yeah, it's pretty gross. But we don't have to worry about that now. Widespread panic. I used to feed my cats raw, but now we have so many, we just do grain-free canned food. Yeah, anything that's moist, because that's part of the problem is that if they eat just dry kibble, they're going to, you know, they need moisture. And Karen Becker says, you know, even if you can just afford just, you know, a can of tuna or, you know, a pound of meat once a week, even that's better for them than just straight up kibble all the time. So... It's really funny though. I do buy them in the store meat, and they generally they don't really like that. If we give them the meat that's you know, processed, non-human grade, I guess, we buy and they gobble that down like there's no tomorrow. But then when I buy the meat that's in like the Publix or the Winn-Dixie or whatever, they kind of sniff at that and they're like, what are you giving us? So then that makes you wonder, why are they not eating that meat? Because that's supposed to be for us. So we have this thing called slop, and it is processed, if you will, but it's canned, and they eat that. So we mix it up. We mix it up for them. Yeah, please leave a message after the tone. Boo. Julie BME, catching up. Meat is the natural food for dogs and cats. People also from the beginning of time have eaten mainly meat. Yep, couldn't agree with you more. Green-eyed cat. I'm at work, but working. Monday zoomies. Nice. Yeah, we do not have the zoomies. Debbie Gibby, the only raw stuff I did for my dog years ago was fry liver for my golden. Yeah, Ola. Gorillas don't eat meat, though. I find that interesting. And do all primates, do they eat, are they vegetables as well, and bananas and stuff? Fruits? Do they eat meat? I forget. Irish Amy, I just can't see this being an accident. I know they keep trying to show different ways it's possible and the difficulties with swinging the rake, but I can't see it as an accident. I have a hard time wrapping my head around that too. All right, so there's 4 possibilities, right? 1, Todd did it. 2, Tristan did it. 3, it was an accident. 4, somebody else that we don't know did it. Those are the 4 possibilities. So if you take away accident, take away Tristan, that leaves somebody else or Todd. You take away somebody else, that leaves Todd. I mean, I guess we could do the Occam's razor, the simplest solution, right? Or the simplest answers. I don't know. It's really, really weird. Fala, should we be worried about where Squeegee gets all this meat? Oh, Rafa! Come in there, little baby. Come here, little bean boy. Oh, come on. Come on. Oh, my goodness. Come here, say hello. Oh, come say hello. Come say hello to the chat. Come say hello. Hi. Meow, meow. That's a good boy. He was out there hanging on the screen. That's a good boy. Yeah, that's my good boy. That's a good boy. Little Rafa. Kitty! Sweet little boy. He was literally I heard it, me, and I look back and he's hanging on the screen door. I guess he wanted to come in. So, I guess that's the daughter. They did have 2 boys and a daughter. Yeah, she kind of looks like everybody's saying hello to you, Rafa. He is cute. Ken, are you in the chat? I see somebody saying hello to you. Okay, looks like they might be back here. Furry greetings to you, Rafa. He's chewing on his... Oh, no, he's just licking himself. Erica Hubner says you're adorable. Okay. Oh, all right. I'll see you guys on the other side.
Morning. Please be seated. Good morning, everyone. All right, we'll go ahead and go on the record. We had some brief discussion off the record regarding the schedule, and I believe the plan this morning, Ms. Thompson, is to begin with Mr. Saffre, and I see that he is on Zoom. Are you able to hear me this morning, sir?
I can, Your Honor, yes.
All right, and we can hear you loud and clear.
Perfect.
Ms. Thompson, was there anything we needed to address before beginning with the witness?
I don't believe so, Your Honor.
Okay, let's see if I can find my camera, and I'll swear the witness in here. 1 second. Too many screens to keep track of here. All right, good morning. If you'd raise your hand, sir, I'll swear you in. Do you swear the testimony you're about to give will be true and correct?
I do.
Okay, whenever you're ready, Ms. Thompson.
Thank you, Your Honor. And Mr. Saffre, are you able to hear me okay?
Yes. Hold on 1 second. Let me just turn this up a little bit. Okay.
Good morning, Mr. Saffre. Can you please introduce yourself to the court?
Sure. My name is Mark Saffre. I am the president of Forensic Behavioral Services.
And what do you do for a living as the president of that company?
I conduct complex assessments of death investigations, death cases for interested parties to help them understand what happened, how those events within the case unfolded, and possibly sometimes why they occurred.
Are you familiar with the term equivocal death evaluation, Mr. Saffre?
Yes.
Can you tell?
Recording in progress.
Can you tell the court, Mr. Saffre, what an equivocal death evaluation is?
Sure. An equivocal death evaluation is an investigation where the manner of death, not necessarily the cause of death, but the manner of death is in dispute or in question, or where there are several possible scenarios that could explain the death.
And I want to get back to that concept with you, Mr. Saffre, but for starters, did you work in law enforcement prior to starting your company?
I did.
And can you tell us in general terms what your law enforcement career consisted of?
Sure. I started in 1977 in California with a local law enforcement city police agency. I started in patrol. I worked about 3.5 years in patrol and then promoted into detectives, started in property crimes, and finished out my time there in violent crime investigation. Subsequent to that, I applied to the FBI. I got into the FBI in 1984. I served in various field offices. I served 23 years in the FBI, the last 12 plus years in the behavioral analysis unit.
In total, how long was your law enforcement career?
30 years.
And in total, how many of those years were with the FBI?
23.
And you mentioned that you worked with the behavioral analysis unit in the FBI. Can you tell me what you did in that unit? Sure.
So I worked there were 3 units. We had a child crimes unit, we had a threat assessment terrorism unit, and we had an adult crimes unit. So I was assigned to the adult crimes unit. I was responsible for, it's a relatively small unit. We had 8 criminal behavioral analysts. I was responsible for the 6 western states of the country, for all cases that came in from law enforcement agencies from those locations. Most of the cases that I worked on were homicide cases, multicide, so serial murder, mass murder, spree murder, sexual homicide cases, and serial sexual assaults, all related to adults.
Did part of your work in that unit involve analyzing crime scenes?
Essentially, everything, despite the services that we offered, everything within the unit requires a detailed analysis of the crime scene in whatever case it is and whatever we're being asked to provide to the requesting law enforcement agency. So it all comes down to conducting a detailed analysis of the scene, the antecedent behavior, the behavior during the scene, evaluating forensic evidence, physical evidence, and integrating all of that information together to understand the totality of the events that are occurring both in sequence and in time.
You told us earlier about this concept of equivocal death evaluations. Did you perform those evaluations while you were with the FBI?
I did.
And did you have experience at the FBI investigating cases where investigators initially believed the case was a homicide, but the case turned out to be something else?
Yes.
Have you published in the area of death investigations?
Yes, I've published, I have a book on spree murders for police investigations. I have numerous peer-reviewed international journal articles on various aspects of death analysis and investigation.
Have you trained law enforcement officers on the topic of death investigations?
Yes.
Can you tell us briefly about your experience training other officers on this subject?
So I regularly do presentations for law enforcement groups and other groups for forensic nurses, victim advocates. I've presented to judges, to prosecutors, to defense attorneys, homicide investigators, violent crime investigators around the U.S. and throughout the world. I would say, conservatively, I would say I've presented to over 20,000 law enforcement professionals.
Are you the member of any professional organizations?
Yes, there's a number of them that I have listed in my CV. American Academy of Forensic Sciences, the VDOC Society, it's a cold case society. Off the top of my head, I have them listed, I just don't recall them now.
In your consulting career since you left the FBI, what kinds of clients have you consulted for?
Well, since I left the FBI, most of the clients are, I would say, attorneys, civil attorneys. So the types of cases that I work on typically involve some type of violent crime. But I've done cases for prosecutors, for defense attorneys, and even for private parties. Sometimes family members will retain me to examine a case. Prosecutors, defense attorneys, and then in civil cases, both the plaintiff and the defense.
Do you have clients for whom you've consulted where the client ended up not using the opinions that you provided to them?
Yes, that occurred both in the FBI when we consulted with law enforcement agencies and also civilly. The cases that I've done in the nearly 18 years since I've been retired from the FBI, there will always be cases where the analysis doesn't line up with what the attorneys are looking for, and then they don't end up using me.
I want to come back to this topic of equivocal death evaluation and crime scene analysis. And for starters, Mr. Saffre, you are not a medical doctor, is that right?
That's correct.
In reaching your opinions about crime scene analysis and case investigation, do you rely on medical diagnoses that are reached by medical professionals in those cases?
I do.
And do you also rely on objective evidence that's gathered by law enforcement investigators and others related to a case?
Of course.
Mr. Saffre, are you here today to offer any opinions on whether any particular person related to the investigation into Ms. Mullis's death is telling the truth?
No.
Are you here today to offer any medical opinions?
No.
And the opinions that you're going to offer today, are those opinions that you hold to a reasonable degree of certainty?
They are.
You talked about this concept of equivocal death evaluation. How does an equivocal death evaluation differ from another type of homicide investigation?
So most of the cases that I've worked on, both in my FBI career and subsequently, typically involve a violent crime, oftentimes a homicide. So the advantage when you are working a case like that is that you know at the outset that the manner of death is homicide. So that's never in question. When you're working an equivocal death case, they actually are much more difficult to work because when you get the case, the manner of death is either in dispute or it's unknown. It could be undetermined, which is one of the 5 evaluations that you can have in the United States for manner of death. So the way that you approach an equivocal death is different than you would approach, say, a homicide case. Here you have to look at all of the various attributes of the case in terms of what is consistent and what's inconsistent with a particular manner of death. Now, I would say that in most of the equivocal death cases that I have worked, when you look at the 4 manners of death, which would be natural, accident, suicide, and homicide, in most of the cases, you can eliminate usually 1 or 2 of the 4. So you're usually left with 2 manners of death that you have to consider. So it's a more complex type of investigation because you have to consider various avenues of consistency and inconsistency with the forensic evidence, the physical evidence, and the behavioral actions that have occurred at the scene, and how all of those translate both sequentially and in a time order or temporally.
Mr. Saffre, did you conduct an equivocal death evaluation into Ms. Mullis's death?
I did.
And did you review evidence related to the investigation into her death as part of your evaluation?
Absolutely.
Can you tell us in general terms what you reviewed?
So, what is important in literally any type of investigation is the initial police investigation. So that would be any investigation they did, any evidence that was collected, any testing of that evidence. In a death case, it would be the autopsy protocol, photographs and diagrams from the scene, any interviews of witnesses, the assessment of the scene itself. That is all the critical information. Typically, in those types of investigations, what occurs weeks or months later oftentimes isn't really relevant to what I'm doing, because I'm doing a crime scene analysis. So it's everything that's attendant to the initial scene, which is typically frozen by police on their arrival.
And I do want to start talking, I want to start by asking you some questions about the scene that you just referenced. Based on your evaluation that you conducted in this case, did you develop opinions about the scene of Ms. Mullis's death?
Yes.
And are you aware that in this case, prosecutors argued to the jury that the scene of Ms. Mullis's death was staged?
Yes, I'm aware of that.
All right. So when we talk about the concept of the scene in the Mullis investigation, what do you understand to be the scene of where she was injured?
Well, okay, so I would say more broadly, the scene is literally the entire farm area of the Mullis farm. If we're referring just to the injury location, that would be the shed that stands between the house and the hog barns.
Is it your understanding in this case that Ms. Mullis died at the hospital?
Yes.
And why do you consider the scene to be the shed and the Mullis farm in this case?
Okay, so I would say I would consider the Mullis farm, or at least certainly the area around the house and the shed and the workshop and the hog barns, as the overall scene area, because there were witnesses and individuals in those locations. I would say that the shed is the location for Miss Mullis's passing, because there's physical evidence in the shed that suggests that. The interviews that were conducted, the information derived from those interviews indicates that, and the police investigation and their theory is that that her death took place in the shed,
In your training,
which I think is accurate.
and when you're talking,
Her injury took place in the shed.
in your training and experience, what does it mean for a scene to be staged?
So staging a crime scene is an attempt by the offender of, say, the homicide, because that's typically where you see staged crime scenes, is in homicides. It's an attempt by the offender to misdirect the investigation. And the way that they misdirect the investigation is to introduce either spurious or fake evidence, remove evidence, or create contrived activities or behaviors that actually didn't occur. And the idea is that the purpose is that they're trying to create a new scene that has a new motive, because that's what they want law enforcement investigators to look at and draw their own conclusion that this is what is actually occurring as opposed to what actually occurred. And so they stage the scene. The reason that staging is, and recognition of staging at a crime scene is important, because strangers don't need to stage a crime scene. They don't have a relationship dynamic with either the victim or the scene or both. So when you see intentional staging, then it suggests that that the offender has some relationship with the victim or the scene or both of those.
So how is it that law enforcement evaluate whether or not a scene is staged?
Well, that's the point. So the offender, he manipulates the scene, either the forensic evidence or the behavioral evidence or the physical evidence. They manipulate the scene to change it so that when law enforcement comes and looks at the scene, that they're trying to overwhelm what law enforcement's logical conclusion about the scene would be, to make them think it's actually something different. So a new type of case that has a different motive. The problem is that when you are staging a crime scene, all of this activity then is happening after the crime. So it's not occurring in the right sequence or the right time order. And so you get inconsistent forensics, you get inconsistent injuries, you may have blood spatter in a location that doesn't fit the crime. So there are a lot of red flags that are evident in staged crime scenes.
Did you see evidence in this case that the scene of Ms. Mullis's injuries was staged in some way?
No.
And can you explain how you reached that determination?
Well, I would say first off, when you stage a crime scene, the point is that you need law enforcement investigators to come to the scene and look at it. You've changed the scene. You've changed the victim. You've changed evidence. You've created something that is supposed to look different. But you need investigators to see it, because you need for them to draw their own conclusions about the scene. Incorrect conclusions, but that's the whole point. So here you don't even have a scene, and that's the point. So there's no staging that's going on here, because investigators, they only come to the shed at a later time.
So why was there no scene in this case?
I'm sorry?
I said, why is it that there was no scene in this case, as you just mentioned?
Right. So there's no scene because, first of all, Amy Mullis is not deceased, and there's an attempt to render aid to her, both in the shed and then subsequently in the truck, and then subsequently at the roadside location where dispatch advises him to stop the truck and meet law enforcement. There's no scene. The victim is not there. Everything is, suggests that Mr. Mullis was attempting to render aid to his wife in getting her to the hospital. So there's no scene to analyze, not for staging anyway.
In your experience, is an aspect of scene staging sometimes that a person that is staging a scene will generate a situation where someone else will find the victim?
Yes, that's very common, and not even in staged scenes, but in other types of homicide cases where it's called, what we refer to it as third-party discovery. So what they don't want is to discover the victim, because then it creates a problem for them because they're not at an arm's length distance. So oftentimes they will have somebody else discover the victim. That could be a neighbor, it could be a coworker, it could be a friend. That puts them at arm's length from both the scene and the victim, and essentially allows them to try to create an alibi.
Well, here you're aware that it was not Mr. Mullis that found Miss Mullis, is that right?
Yes, I'm aware of that.
And
yes.
in your evaluation of this case, did the circumstances of this case fit the third-party discovery dynamic that you just described?
I would say no for two reasons. One, in every third-party discovery, in any case I've ever worked, or any case that I'm aware of from my time in the FBI's behavioral unit, or in my 18 years subsequent to that, I have never seen a third-party discovery where a parent sends a child to make the discovery. It's typically an adult contacting another adult, not a family member, but, as I said, neighbor, friend, coworker, somebody that's disconnected personally, in a sense, from the victim. So that's not my experience to have sent. I've never seen you send a minor child to find the parent. Secondly, it doesn't really work here because there's nobody here at the Mullis farm. This farm is isolated. It's out in the country. There are no houses around it. There were no other people. So it doesn't make any sense to send, if you're trying to do third-party discovery, it doesn't make any sense to send your minor child to make the discovery. For one, there's nobody else around, and two, the time frame is literally minutes. So we're not talking about hours or days. We're just talking minutes. So it wouldn't serve any purpose in terms of distancing yourself from the scene to send your minor child.
Did you see evidence in this case that Tristan Mullis was interviewed by authorities, soon after the events that brought Miss Mullis to the hospital?
Yes, he was interviewed within minutes after the event.
Did his availability for interviews influence your conclusion that there's not evidence of third-party staging here?
Yes, partially. It's one of the things that I would say is consistent with it. Because he's a minor, you have to have parental permission to interview a minor. And Todd gave permission immediately for Tristan to accompany law enforcement back to the house to show them and tell them what he saw, what he did, what he found. And so that's inconsistent, really, because if you're the offender, you don't want a third party to be making statements that might, affect your credibility or, whatever you've told law enforcement.
And did you see evidence in this case of Mr. Mullis interrupting or preventing law enforcement from interviewing Tristan without Mr. Mullis there?
Your Honor, I'm going to object to this line of questioning as improper expert opinion testimony because it's a comment on credibility not only of Todd Mullis but also of Tristan Mullis in this case. Credibility is a determination solely for the fact finder, and it is not subject to expert testimony under 570(2), 3, and 4, I believe.
Overruled.
I think I did not get an answer to that question, Your Honor. Is that correct?
I didn't hear an answer. You may.
No, yeah, I didn't. Can you just repeat the question? I'm sorry.
I'll have to have the reporter read it back since there was an objection, so we'll give her a chance to do that.
Thank you.
And did you see evidence in this case of Mr. Mullis interrupting or preventing law enforcement from interviewing Tristan without Mr. Mullis there?
No, there were two instances where law enforcement asked Mr. Mullis if they could interview Tristan. One of them was immediately after, from the roadside location to accompany Tristan back to the house to explain the whole situation there. And then later on that day, they also asked him again, and he said, sure, go ahead.
Did that permission impact your conclusions here about the scene not being staged?
I think, as I said, I think it's one piece, right? Because clearly, if you don't know what someone's going to say, especially with a minor child, it would be very easy to say, I don't want you to talk to him, or I want him with me, for whatever reason. So I think it's a piece that, lends itself to suggest that he didn't care what Tristan told law enforcement, because it was going to be what Tristan's experience was that morning.
Did you see evidence in your equivocal death evaluation in this case that there was planning involved in some way in someone hypothetically causing Ms. Mullis's death?
Right. So, I don't see any staging in this case, and I don't see any planning. If the allegation is that it's staged, I think if it's planned, it would be very, very poorly planned for several reasons. One, the weapon is really a terrible weapon. Can it inflict fatal injuries? Yes. But is it a good weapon to use? No. If you're planning this, you don't want your children around. You don't want to be in a position where you literally would have to escape from your son to commit this. And also, you have two other minor children in the house, a 10-year-old and an 8-year-old. You have no control over them. You don't know where they're going to be, if they're going to come outside, if they're going to go to the shed. That they played in the shed. So it would be extremely risky. So to do that with your minor children would be, problematic. Farm accidents are very prevalent. So if you're going to plan this, if you've spent time to think about this, then there are lots of other ways that this could have occurred that didn't involve your minor children and didn't involve a very odd type of weapon like a corn rake, and it would have given you the privacy to interact with Amy at another location, somewhere off the farm property. But I just didn't see any evidence of planning, because I don't think there's no staging here. And if this is planned, it's extremely poorly planned.
Did the fact that Ms. Mullis passed away at the hospital in this case, is that a fact that you took into account in evaluating whether or not there was planning associated with her death?
Yes, because the idea in a staged crime scene, one, is that the victim is deceased, because you're going to be manipulating the scene, manipulating the victim. So the victim has to be deceased, because if they're not deceased, then there's a possibility they can move away, get help, render the aid to themselves. It becomes very problematic. So the fact that she's not deceased, again, in terms of planning, if this was the plan to kill her, then, that didn't succeed.
If Ms. Mullis was, if there was evidence in this case that Ms. Mullis was the person who suggested the family work in the barn the day of her injuries, would that contribute to your analysis of whether or not Ms. Mullis's death was planned in some way?
Yes, it affects it because because of her medical procedure, she had been unsteady, dizzy. She'd been resting at the house for several days. So it was, I believe, only on that morning when she informed Todd that she just couldn't sit in that house anymore and was going to come out and try to help in the barn. So again, how would you know this? You really wouldn't know it. So it goes against planning. Additionally, in terms of the planning, if you're trying to stage this, so then you have to know where the corn rake is, right? You have to be able to tell police, I saw the corn rake there yesterday. I was in the shed yesterday. I saw the corn rake. It was right here. So because it has to be, the scenario would have to make sense, right? You're trying to make it make sense to the police. So yes, you're going to tell the investigators, yes, the corn rake was in the shed. I saw it in the shed. This is where I saw it, right? But that's not what you have here. Instead, when they asked Todd where the corn rake was, he's like, I don't know. I hadn't seen it for 2 weeks. Last time I saw it, weeks ago, I'd set it against the wall, but I don't know where it was. So that doesn't make any sense if you're trying to stage a crime scene, right? You're trying to make law enforcement believe that this is, an accident, right? That's what you're trying. So you need to have the corn rake there, to confirm that for them, but it's not. And I don't think Todd knew until that morning that Amy was planning on coming out to the hog barns.
Is the topic of victimology relevant to equivocal death evaluations?
Yes, victimology is relevant to any type of crime analysis because understanding the individual whose life is taken or who dies, is really important to understand their background, and what effect that has on risk level for them. So understanding that background, all aspects of that background from their various types of histories, could be criminal or psychological or financial, their relationship dynamics with friends, coworkers, family members. All of that information is important to understand, who is Amy Mullis and, what's that dynamic relationship between her, Todd, other people in her life.
Is that what that term victimology means, what you just described?
Yes, right. And it also, especially when you're talking about risk, you're trying to assess at what level of risk is she to become the victim of a violent crime. But on the flip side, you're also, that also informs the level of risk that an offender is willing to take to commit the crime. So if you have a very low risk victim, which I would say Amy is, not only because of her lifestyle, but simply because she lives in a very isolated location that's difficult to really find and get access to her. But also, sorry, lost my train of thought. Also because, the risk would be very high for an offender to access her there. So risk is a balance between the victim and the willingness for the offender to take on, more risk. And the more risk an offender is willing to take, then the more important it is for them to, commit whatever act they're, preparing to commit.
Well, in considering victimology and in considering risk, in general, in conducting these type of equivocal death evaluations, do you consider the concept of infidelity in making that analysis?
Sure, if that exists, if it's relevant. So there are lots of different components to victimology, and their relationship dynamics in the relationship dynamics in her relationships would be important. So if it's uncovered that there's marital infidelity, certainly that would be important to understand.
Well, in conducting this equivocal death evaluation, did you consider the issue of infidelity in the Mullis marriage in reaching your conclusions?
Sure, absolutely.
And how did that fit into your analysis?
Well, so once I was aware of it, then I have to put it in context, right? So everything that's done in my type of analysis is always within context. It's always within the totality of the circumstances. It's never a single piece of evidence that, is pulled out and assigned a value. It only has meaning within the context of everything you're looking at. So when I became aware that she had this affair with Mr. Frazier, then I wanted to take that into consideration. What do I know about that? Who knows about that? Did Todd know about that? What's that dynamic? What is that dynamic like? So, of course, is a very important piece.
And did you draw any conclusions about how, if at all, infidelity would have played a role in the victimology in this case?
So, one thing I really wanted to understand is, was Todd aware of it? Now, clearly there had been a past infidelity that he was aware of. But in this current one, based on the emails and the texts between Amy, Jerry Frazier, Mr. Frazier's wife, several of her friends whom she confided this infidelity to, there's nothing that I was able to see that led me to believe that Todd was aware of the infidelity. I mean, Amy said he wasn't. Jerry said he wasn't. In fact, there was a questioning by Todd in, I believe it was July of 2018, where he had seen a number of texts between Amy and Jerry and asked Jerry about them, or I think asked Jerry about them, and was given what appeared to be a reasonable explanation for it, and then spoke to Amy, and to the extent that I think he felt badly that he had thought there could be something going on, and actually apologized to Jerry and to Jerry's wife. And in texts between Jerry and Amy, they were very confident that Todd was not aware of the affair.
In considering the issue of victimology, in assessing risk factors as you've described, do you as an investigator think through the dynamic of someone reporting events differently to different people?
Sure, absolutely.
And did you consider that dynamic in this case?
Of course.
And what, if any, go ahead. Go ahead, Mr. Saffre.
Well, so certainly, I mean, all of us have different relationship dynamics with people. We have our public lives, we have our private lives, and, some people have a secret life. But It depends on the relationship dynamic with your friends. So some of your friends are more distant. They're almost more like acquaintances. And other friends are people you see all the time. And then other friends are like really close friends. That could be the same for coworkers. So when the stories and the conversations that you have with different people in your life basically reflect the level of comfort you have with them, what you will tell them. And so you see, when you look at the conversations that she has with several of her friends and with Jerry, you can see the difference in the conversations, and that, I think, would be expected.
Do you need power? Yeah. There's a power strip right in front if you can reach.
Yeah, and I had him check it.
I did get an answer to the last question, right? I don't need it read back. I just want to make sure. Okay, thank you. Did you see evidence in your evaluation, Mr. Saffre, that there were communications between Ms. Mullis and Jerry Frazier where Ms. Mullis was critical of Todd Mullis?
Yes.
And what, if any, conclusions did you draw from those communications in terms of Ms. Mullis's victimology?
I didn't think that there was anything wrong with those. She has this secret affair going on with Mr. Frazier. She's violating her marital vows. There's probably some level of fantasy that's going on here. So I think based on the conversation she was having with Jerry, at some point, she feels badly and she's looking for someone to sort of buoy her up, right, support her, almost, I don't want to say like a victim mentality, but certainly, that kind of, where it's, she's looking for sympathy. She's looking for someone to, provide support for her, right, to make her feel good. I think those kinds of texts with Jerry, if you're commenting on your relationship with Todd, I think it, makes sense, when you're talking to somebody who's, your secret lover. I didn't see anything that, that caused me any kind of, concern.
Did you see any differences in the communication between information that Ms. Mullis was conveying to Mr. Frazier and information that she was conveying to Todd?
Sure. I think, she's married to Todd. She has children with Todd, right? They have a business together. So some of the texts that she's sending Todd are very playful, loving, discussing things that I think any normal couple would be discussing, things happening on the farm, breakfast, just sort of innocuous kinds of conversations. She did say that she loved him, but of course, she's got this secret side of her. So obviously she's not going to tell Todd about that. But it doesn't mean that she doesn't care about Todd. And I mean, that's the sense I got in reading a number of messages. And you can't just read one. You have to put them in context. You have to read a lot of those, and a lot of those messages to her friends, and evaluate what is that relationship? What is she comfortable telling these different people?
And Your Honor, again, I'm going to object on well beyond the scope of expert testimony. We're just commenting on text messages and things that are well within common sense and reason, and that is not subject as a reliable expert opinion under 5702 and 03, and therefore should be excluded under even 403B.
I mean, I do think we're getting pretty far afield here, Ms. Thompson. If you want to try to tie this back in, that's okay, but I'm not sure what your next question is.
I mean, I'm moving forward, Your Honor. I would just say that there was some testimony from Mr. Firehelm that he personally, in his analysis of the case, believed that there were, and I don't remember his exact words from yesterday, but that basically his own evaluation of the marriage was different than what Mr. Saffre's describing. And one of the ineffective assistance of counsel claims that Mr. Mullis has is that his counsel didn't consult with someone who could have provided context. So this is relevant to Mr. Mullis's ineffective assistance of counsel claim. I agree that, and it's not this witness's intention or our intention to argue that this witness can provide, veracity about these issues, but more context for counsel to have evaluated the issues here and how to present them for Mr. Mullis.
Your Honor, if I may be heard.
You may.
Well, that's certainly not what he authored the report for, to comment on Mr. Firehelm's testimony. He makes direct credibility determinations, and he coins it under a term, victimology. There's at least 2 cases which have excluded his analysis, specifically on this point, and reversed for new trials as it being inadmissible in the first place, and therefore unreliable. I'm happy to provide those citations now. They're from the Illinois Supreme Court, where they find the entirety of this testimony and line of questioning to be inadmissible, as did the New Jersey court that they relied on too, because it's the equivalent of testimony from a 13th juror to parrot in a theory of a case. That is improper testimony, and we would vehemently object under the expert testimony provisions in 403.
Yeah. And certainly little different to have the testimony of trial counsel's analysis of the case and attempting to get the testimony in this way through an expert. So again, if you can have him explain how he's qualified as an expert to talk to me about this specific type of testimony in a way that isn't vouching or credibility, which is my domain, I guess we can try to go there. But the way this direction is, or the way this testimony is going, seems to be down that path at the moment. So let's maybe redirect and get back into something that I think is his domain with these investigations, or the way in which he handles them, please.
Understood, Your Honor. And we can take up the issue of that case law because we disagree with what it says, but I understand the court's ruling, and I'll move on to a different topic.
Thank you.
Mr. Saffre, are you familiar with the concept of confirmation bias?
Yes.
And can you tell us in brief terms what that is?
Well, I would say in reference to like a criminal case, the investigators are more likely to search for and recognize what confirms their bias or their theory and ignore or not consider evidence to the contrary.
Did you see evidence of confirmation bias in the investigation into Ms. Mullis's death?
And I'm going to object again, Your Honor. This is psychological evidence, and it's been kept out before because they do not he has no experience as a psychologist. He has no medical experience as a psychiatrist. What is the point of this testimony? Again, under our reading of the case law, courts have kept out the very same thing and found it to be improper, and we would object on those grounds as before. It's the same grounds as before.
Did you wish to respond to this, Ms. Thompson?
Well, the case law that the primary case in Illinois in which a court determined Mr. Saffre's opinions were not relevant actually dealt with his assessment of a crime scene. If the state is referencing People versus King, we can talk about that case. This is not testimony that's offered to provide the purpose of this testimony is to talk about what this investigation was and why it is that both Mr. Mullis's own attorneys and investigators focused on incorrect information. And that is within Mr. Saffre's province as an experienced FBI investigator, as an experienced law enforcement officer who evaluates these cases. It's to understand why both Mr. Mullis's own attorneys and the authorities would have focused on particular issues without looking at others. And that's relevant to understanding why it is that Mr. Mullis didn't receive effective assistance of counsel and why it is that this investigation got off track, which again is one of the claims that Mr. Mullis raises in his petition.
And again, Your Honor, if I may, Mr. Saffre's report doesn't speak to that. The ultimate conclusion as set out on page 56 and 57 is meant for him to speak to whether or not this was an accident or a homicide. Specifically, if we look to his conclusion, he said, quote, "I was asked to review this case to determine if a manner of death other than homicide would provide the most logical explanation for Amy's death," close quote. I believe that's at page 57, Your Honor. Possibly 58. And so Mr. Saffre's conclusions certainly aren't being relevant to an ineffective assistance of counsel claim. And again, improper testimony invades on the fact finder's function here.
Ms. Thompson, any further response?
Mr. Saffre has not offered an opinion about the cause of death here, although he certainly has one, as the state alluded to. There's nothing about, and his report does discuss the topic of confirmation bias and how that is relevant here. These opinions are just as relevant for what counsel would have taken into account in choosing whether or not to investigate, choosing whether or not to make certain arguments on Mr. Mullis's behalf. That is exactly the purpose of his report. It's information that counsel could have taken into account. That's exactly what we offered it for in our petition, that counsel failed to get this kind of expert opinion which would have aided in counsel's analysis. There is nothing about Mr. Saffre's report that is inconsistent with presenting it in that way. We have not presented Mr. Saffre's ultimate opinion in this case. That is the province of the court. But these are all the factors that he could have explained to counsel, which would have helped counsel understand what evidence would have been relevant to arguing this case to the jury in Mr. Mullis's case. And I'd say that there's a number of other cases where Mr. Saffre's analysis and opinions have been accepted by courts, and we have a number of those cases we can cite to the court. So the state has pulled out, a couple where courts went the other way, but that's not Mr. Saffre has testified all over the country, and his opinions have been accepted by courts in numerous states.
To the extent that the court understands Mr. Saffre to be offering an opinion as to the investigation that was conducted into this matter, and not an opinion or as an expert on confirmation bias specifically, the court will allow the testimony and give it whatever weight it's ultimately due. So the objection's overruled. You may proceed, Ms. Thompson.
I'm sorry, what was my last question? And I apologize because I don't recall. I believe the last question may have been.
Did you see evidence of confirmation bias in the investigation into Ms. Mullis's death?
Did you hear that question, Mr. Saffre?
Oh, I didn't. No, I did not.
Let me repeat it. Did you, Mr. Saffre, see evidence of confirmation bias in the Mullis investigation?
Yes.
And can you explain what evidence you saw of that?
Well, I think the first really important piece here relates to the interviews that were done of Tristan and Todd. It's important to understand that the first three interviews of Todd, two of them occurred. The first three occurred on the day, on the 10th. the first three interviews of Tristan, or first two interviews of Tristan, also occurred on the 10th. At no time were those interviews conducted with Todd and Tristan together. They were all conducted independently. In fact, all of the interviews that were conducted, including the ones on the 16th, were conducted independently. So normally in law enforcement, when you have two suspects and that are suspected in a crime and law enforcement arrests them, the first thing that law enforcement does is separate them. Why? Because they don't want them talking and getting their story together. I mean, this is an investigation 101. And that's exactly what happened here. We have these literally 7 interviews of a 13-year-old boy and Todd explaining to law enforcement on the day. So this isn't occurring weeks later or months later or years later. This is happening contemporaneous with the crime. And what we know from investigations is that the best information from a witness is that contemporaneous information to the event. So the closer to the event, the better. Because you don't want that information contaminated. You don't want that person talking to other people.
Objection.
Or other
Vouching, improper testimony. Again, what he's saying is, if I understand it, and certainly the court can make the determination, is that they were telling the truth because their stories were closer in time to the events in question. How is that not a credibility determination, saying they were telling the truth then but were not later on?
Well, and I think the answer is turning into a narrative. Let's just have a new question, please, Ms. Thompson.
I'll ask another question, Your Honor. Did you see evidence of confirmation bias in the way that authorities relied on the text messages and the messages between witnesses in this case?
Yes, in certain circumstances I did.
And can you explain what evidence of confirmation bias you saw in that respect?
Well, there was a couple of texts that Amy had related to a confrontation that she'd had with her mother-in-law, Peggy Munson. And those texts, if you take the text out of context, it appears that Amy is talking about Todd, that she's going to, if this ever happens again, I'm going to leave, take the kids. And then, so it sounds very damaging by itself, but if you take it within the context of all of the other texts, you realize that she's not talking about Todd, she's talking about her relationship with her mother-in-law and the problems that she had there. And that goes on for a couple of days. And she even has that discussion with Todd. So I think it's really important that you take all of these conversations in context and look at what's going on before and after the conversations.
Just one moment, Your Honor. The text messages that you were just referencing, Mr. Saffre, do you understand that that Miss Mullis's mother-in-law in this case was Elaine Mullis? Do you recall? Go ahead, Mr. Saffre.
Sorry?
Do you recall, as you sit here today, the name of Mr. Mullis's mother-in-law or Miss Mullis's mother-in-law?
Yeah, sorry, I misspoke. Right.
In general, the testimony that you've provided today, if Mr. Mullis's counsel had consulted with you before Mr. Mullis's trial, is this information that you could have provided to Mr. Mullis's attorney?
Yes.
I don't have any other questions, Your Honor.
Cross-examination.
Yes, Your Honor. Good morning, Mr. Saffre.
Good morning, Counselor.
How long have you had what was your experience length in law enforcement specifically?
In law enforcement?
Yes.
Well, I started in 1977 as a police officer working in patrol. As I said, I promoted into detectives, started in property crimes, went to violent crimes. And then in 1983, I applied to the FBI. I got in, and my first office was working in Indian Reservation in Wyoming. I worked there for 3.5 years, working all the violent crimes on the reservation. I went and then was transferred to the New York City office. Is this what you're looking for? I just want to.
Mostly, I was just trying to check. I believe it's 30 years or so that you had in law enforcement, right?
Oh yes.
So is the bulk of your experience testifying in court is actually from an agent perspective, correct? Or an officer perspective too?
Well, I was a supervisory special agent in the behavioral analysis unit.
Right, but in court cases specifically, is the bulk of your testimonial experience when you've taken the stand has been as an officer or an agent, right?
Yes.
And your background is in law enforcement specifically, fair?
That's very broad. I don't know what you mean by law enforcement.
You have no expertise or specialization in psychology. Fair, you're not a psychologist?
Correct.
Not a psychiatrist?
Correct.
As you confirmed on direct examination, you're not a doctor, right?
That's right.
So you're in the fields of psychology, such as social psychology, you aren't able to speak to the dynamics between people, fair?
No, I wouldn't say that's true.
Well, you are not a social psychologist who has been certified to testify on that matter specifically, the social psychology of interfamilial relationships, right?
No, I testify about relationship dynamics all the time as an expert witness.
Correct, but your primary expertise, in fact, for the bulk of it, your expertise is in the field of crime scene analysis or law enforcement investigation, right?
Well, I would say that crime scene analysis is the baseline for all of the type of analysis that I do, yes.
And in your report, you detail it as crime scene analysis as being your primary expertise as well, fair?
I don't know that I detail it in my report that way. As I said, crime scene analysis is sort of the bedrock of all of the type of analysis that I do in complex death assessment cases, whether they're homicides or serial murders or equivocal deaths. I have extensive training in that area.
Correct, but on page 3 of your report specifically, you say, quote, 2 published appellate opinions allow my expert testimony in crime scene analysis, right?
Right, I have lots of opinions. I have lots of appellate courts that have upheld my testimony. Many times I only put those in there because they were published opinions.
Well, the Illinois Supreme Court also issued a published opinion in People v. King. Are you aware of that case?
I am, yes.
And they found, in that case, would you agree that the appellate court or the Supreme Court of the state of Illinois found your testimony inadmissible in its entirety, correct?
Yes.
And it relied on a similar case by the New Jersey appellate court as well, finding similar testimony on profiling, for instance, or what your testimony was being offered in that case went beyond the bounds of your expertise, correct?
I've never testified about profiling. Profiling is not allowed in the court. Profiling is essentially linking the defendant to the behaviors at the crime scene that would interfere with the purview of the jury and the court and the judge. I've never testified about criminal profiling. And
not even in the case of...
Are you speaking about the Forden case?
Well, on the matter
You're talking about the New Jersey. Are you talking about New Jersey? Is that the Forden case?
I believe it's State v. Lennon, if that sounds correct.
Yeah, that's the Fortin case, yes.
And similarly, you were found or profiled as an ex-FBI profiler in the case of, I believe, Raymond Lee Jennings, correct? Are you familiar with that case?
Objection.
Yes.
It just, the question, I think, was you were found or profiled as an expert. I just didn't understand the term that the counsel was using there, Your Honor.
Did you wish to clarify, counsel? I mean, I guess I heard the witness answer, so apparently the witness wasn't confused.
I mean, I can clarify, Your Honor, but the witness already answered the question.
I guess, Ms. Thompson, if you just want to come back on redirect, you can clarify.
Understood, Your Honor.
Well, you mentioned that you've never done profiling before, and you would agree that it would be inadmissible testimony to do a profile, correct?
Yes.
But similar matters, or I guess your testimony in People v. King at the appellate level labeled your testimony profiling of characteristics consistent with crimes. Would you agree with that?
I don't know how they characterize it, but I've never testified about profiling.
So today you're not providing a profile, for instance, of who would have committed this crime, right?
No.
But you are profiling the victim in what you've coined as victimology, right?
Right. You have to understand the history of the victim is when you're looking at a death scene case.
You comment on her behaviors as being manipulative or otherwise, right?
Objection, Your Honor. That was not his testimony today.
Overruled. The witness can answer if he's able.
So part of so you're taking things out of a context here. I said that when you look at Amy's conversations with various people, she presents a different side of herself to whomever she's talking to. That is a relatively normal thing most people do, depending on the relationship that a person has with the person they're talking to.
But you would agree. Thank you, Mr. Saffre. But my question really was, you refer to her at times as being described as manipulative or otherwise. Fair? In your report?
Yes, I did.
So those findings comment on her characteristics as a victim, right?
Well, I've characterized a lot of things about her.
Right, her personal traits, fair?
Right, and this was also referred to by other witnesses who described her the same way.
So I guess, Mr. Saffre, you're just is it fair to say that you drew all of your inferences from the existing record evidence established or collected by law enforcement on this side of things, or presented at trial? Is that about right?
Well, I didn't do any independent investigation. I didn't, go to the scene and conduct an investigation. So, as I always do, I have to rely on the reports and the investigation conducted by law enforcement and others associated with the case, like the medical examiners and toxicologists and such.
But on direct examination, you testified that there was no scene in this case. Is that right?
There was no staged scene.
Well, you would agree that Amy Mullis was found on her hands and knees on your review, right?
She was found with her hands tucked under her, yes, lying on the floor in the shed.
And she was found impaled by a corn rake?
Yes.
And you would agree that based on the evidence you reviewed at least, Mr. Mullis sent his son to find the pet carrier check on it, right?
Correct.
And ultimately sent him in to find his mother, true?
I don't think he sent him to find her. He sent him to get the pet carrier.
And in doing so, find his mother, right? Or found his mother?
He did.
And then Mr. Mullis grabbed the corn rake and pulled it out of Miss Mullis's back, right?
Yes.
And in doing so, touched the weapon, in this case, or what would be called a poor weapon, I believe, as you characterized it, right?
Yes.
And so there wouldn't be any DNA evidence specifically that you'd be able to pull from the handle of the rake, right?
Why wouldn't you be able to pull DNA evidence?
Well, let's say fingerprints. Mr. Mullis's fingerprints would be on the rake then, right?
They could be.
So in your experience of 30 years in law enforcement, you would agree pulling latent prints might be difficult, right?
Pulling latent prints depends on the surface you're pulling them from. So if you have an old, worn, dirty corn rake handle made out of wood, probably be difficult to pull latent prints.
And so when Mr. Mullis pulled the corn rake out of Amy Mullis's back, he discarded it next to her at some point, right?
Yes.
And you would agree that based on the record evidence, Mr. Mullis admitted to putting the rake in that shed, correct?
Well, yes, his recollection was that, 2 weeks prior, he set it against but he hadn't seen it since. Set it against the wall, but hadn't seen it since.
But he was the last person, based upon your review of the records, who knew or saw that corn rake with any certainty, right?
Yes.
And it was Mr. Mullis who sent Amy Mullis to get that pet carrier, correct?
Yes.
So he sent her to a specific location, right?
Yes.
For a specific purpose, right?
Correct.
Where nobody else would be, true?
Well, he didn't know that his other children wouldn't be out there.
Well, you're speculating on that front, fair? You don't know one way or the other. You have never interviewed those kids, and you have no testimonial statements one way or the other as to whether he thought they'd be in there, right?
Objection, Your Honor.
No, but look, I'm looking
sorry,
at this.
Mr. Saffre, there was an objection.
Oh, I'm sorry.
I'll withdraw the objection, Your Honor.
Oh, now the objection's withdrawn. You may continue your answer.
So I'm looking at all of this is what is reasonable. What is likely by reasonable inference. So the information is that Todd and Tristan were in the hog barn with Amy for an hour maybe. So there's no way he would actually know where his other two children were.
Well, he left them inside the house, right?
Yeah, but they're 8 and 10. They're kids. So
well, in the middle of...
You'd have to be certain
but
they weren't going to be outside.
But you can't be certain that he didn't know they were going to remain inside, right? Because you don't have any independent information and you have conducted no investigation yourself, right?
Correct.
You speak at length about the manners of death to be investigated, right? The 5 different manners of death that are recognized, true?
Well, just in terms of an equivocal death evaluation, yes.
But ultimately, you agree that in your conclusions, you were asked to provide an opinion on whether the manner of death in this case was homicide or that there was a more logical explanation for Amy's death, right?
Right. When I got the case, I didn't know anything about the case in terms of, I knew how she died, but what the manner of death was, I didn't know. That was my point. It was to conduct an equivocal death evaluation that basically determined that it was either going to be that the 2 most consistent manners would either be homicide or accident.
So your conclusion was the 2 most consistent manners of death, in your opinion, would be homicide or accident?
Right, because there was nothing there that indicated this was a natural death, and there was nothing, in my experience, in terms of having seen well over 4,000 homicide cases and death cases, that this was a suicide. So, by reasonable inference, you're left with either accident or homicide.
You would agree that Google searches in the history as introduced at trial, though, about, quote, what happens to cheaters in history, and, quote, killing unfaithful women would point to potential motive or any purpose, right, based upon your understanding of planning?
Well, see, counselor, I think you're taking that out of context. That's not very good of you to do that. It's completely out of context. Those searches appeared to be related to schoolwork.
Your testimony today is that, quote, killing unfaithful women was a school assignment? You're
taking it out of context. I think that's my opinion. There is information that suggests that these were searches done by the kids.
And I might have missed it in your report. Did you at any point reference those Google searches?
No, I did not.
So nothing that would have potentially cut against the point. You only found one factor that weighed in favor of finding it was a homicide, right?
Objection, Your Honor.
Yes, I did.
The basis of your objection, Ms. Thompson?
That's a compound question, Your Honor, but the witness has answered, so I'll withdraw the objection.
The objection's overruled. The answer will remain in the record.
And that was that most women are murdered by people they know. That's right?
Yes.
But you didn't weigh any other motive evidence, did you?
Counselor, I reviewed all this information in detail. I was open to the possibility that this was a homicide, and that counsel that contacted me was, incorrect. And that was my job, to figure out what, based on the information and my review of all the information, what was the most likely and consistent manner of death. That was my job, and I considered it a homicide as well.
Well, correct me if I'm wrong, but in your report you don't mention Tristan Mullis's trial testimony, do you?
I don't know. I listed everything that I used, that I received and reviewed. I have to say that I wrote this report in the end of 2022, beginning of 2023, so it is several years old for me at this point. But I have listed everything that I reviewed.
Well, I'll ask you this question. Do you recall anywhere in your report that you testified to your conclusions at length on direct examination, for instance? That report, do you mention Tristan Mullis's testimony that Todd Mullis's father was out of his sight for an indeterminate amount of time?
If you can reference to me, I believe you're referencing an interview with Tristan that occurred well over a year after the incident.
I'm not, Mr. Saffre. Did you review the trial transcripts in this case?
If I have them listed, I did.
But you don't make reference or note them in your report, do you?
Well, I listed in my report what I reviewed.
So I guess I'll phrase it in the hypothetical then, Mr. Saffre. In your opinion, if Tristan Mullis under oath swore that his father left the hog barn and left his site for an indeterminate amount of time at trial, would that change your testimony?
No.
Why?
Because, as I said before, the initial interviews are, in my experience, the most accurate, and when they're contemporaneous with the event. They were unfiltered, unbiased, unimpeded. There was nobody to influence him. By the time trial has come around, what he heard and who has talked to him and who has influenced him, I don't know. But those kinds of that kind of testimony is problematic for me. I relied on the contemporaneous interviews done by law enforcement on that day, multiple interviews with both Tristan and Todd, independent, where their stories were exactly the same.
Well, Mr. Saffre, I'm going to ask a follow-up question on this one. Does it change the fact that at each time Tristan Mullis took an oath to tell the truth and testify in a deposition or a court proceeding like you did today, does that weigh in favor of finding that to be a potential protective factor, that maybe this was a homicide?
Again, I reviewed in my complete review that everything suggests that this was not a staged case and that this was not a homicide.
Correct. But my question was, does Tristan Mullis's sworn testimony that Todd Mullis left his site change the fact that those are his under oath statements, and the statements you reference were not under oath.
Objection.
I understand.
Objection, Your Honor. That misstates the testimony and the facts in this case.
Overruled, the witness can answer.
Yes, I understand what you're asking. I understand that those statements were under oath, but I would consider them. But I would say that in the context of everything that I reviewed, the contemporaneous statements made by a 13-year-old boy were accurate, and he repeated those statements. And not only that it's consistent. His statements and Todd's statements are consistent with what would be expected if you found your wife, unresponsive in a shed. Those activities of lifting her head and wiping her face, all of those things are consistent with somebody rendering aid, yelling at your son to get the truck. Those are all consistent, and those statements were consistent. So I would value those statements in the context of everything that I reviewed more than I would the statements under oath.
So the sworn testimony is less than the unsworn statements, yes? Did I just understand that correctly? I'm only confirming as a yes or no.
Sure. Yes. Yes. That's how I would view that. Yes.
Do you have your report in front of you, Mr. Saffre?
I do.
Can I refer you to page 6 if possible?
Certainly.
Let me know when you're there, please.
I will. Okay.
In the first paragraph at the top of page 6, in the last sentence, I believe, I'll read aloud and let me know if I read it correctly. Quote, "In this case, I yielded the attempt to reconstruct an exact sequence of events. Such an attempt is impractical due to the innumerable possible interactions between Amy, the environment, and others." Did I read that correctly?
Yes.
In your opinion, then, an accident reconstruction wasn't feasible here. Is that fair to say?
No. What I'm saying is that oftentimes when I'm questioned at trial, counsel will ask me, isn't it possible that this could have occurred? And generally what I would say is that when you're dealing with what's possible, literally thousands of things are possible. It's impossible to know the exact sequence to the second of what is actually occurring. So rather than dealing with possibilities, which is nearly impossible, my job is to look at what is likely by reasonable inference from the evidence, the physical evidence, behavioral evidence, forensic evidence. I can't deal with what's possible. The possibilities are endless.
Well, I appreciate that, Mr.
Saffre. What I'm saying there.
I appreciate that, Mr. Saffre, but on page 6, you are speaking about reconstructing the exact sequence of events, correct?
Right.
And so you said such an attempt to, quote, reconstruct an exact sequence of events, I believe those are your words, is impractical, right?
Correct.
So in your opinion, it would be impractical to be able to speak to any certainty about the exact sequence of events, right?
Yes, you can't speak to certainty about the exact sequence, and I can't know the exact sequence of literally any crime that I have looked at. But I can draw reasonable inferences based on the evidence.
So, just to clarify, I guess, as we work towards the end here.
Sure.
We can agree that Todd Mullis asked Amy Mullis to go get the pet carrier, right?
Yes.
So he sent her to a location, right?
He did.
And we can agree that at least Tristan Mullis's sworn testimony was that his father left his site for an immeasurable amount of time, or an unknown amount of time, right?
Objection, Your Honor. That misstates the testimony.
Well,
I don't know what the sworn testimony was.
The answer will remain in the record.
But you referenced and cite in your report, which you have in front of you right now, Mr. Saffre, that you reviewed the trial transcripts, right?
I don't know. I have multiple pages of things I reviewed. I don't recall if I did, or if it's listed here, I did. I just, I just have multiple pages, and it was a couple years ago I wrote this, so.
In this period of time, you have never once evaluated reports or information provided by a Valentina Nye, for instance, right?
I'm sorry, by who?
That, I think, answers my question. You haven't referred to reports or reviewed reports from one Valentina Nye, right?
No, I have not. Dr. Nye? No.
Correct. Dr. Nye would be a way to refer to her.
That's correct. I have not reviewed any reports of hers.
And your conclusions around the scene and the distances between buildings aren't based on your research or your findings specifically, right?
Right. I relied on other experts who conducted those measurements.
And would you agree that there is a difference or a distinction between one being dead or deceased and one being pronounced dead?
I'm not clear on your question.
Sure.
Someone's dead or they're pronounced dead?
So Amy Mullis was pronounced dead at the hospital, correct?
She was.
But she was found unresponsive in the shed on your review, correct?
Yes.
And there were not signs of life accordingly at that point in time. Is that a fair description of the evidence or the record?
Objection, Your Honor. This is calling for a medical opinion from this witness, which he stated he's not providing.
The witness can certainly, I guess, testify as to his understanding based on his review of the records. I won't interpret his testimony as providing any medical opinion. With that understanding, Mr. Saffre, you may answer the question if you remember it at this point.
I do. Thank you, Your Honor. Yes, I don't believe there was there's anything that indicated that she was dead in the shed. She was transported. They were doing CPR on her at the roadside, and I believe, if my recollection serves me correctly, that the doctors in the hospital worked on her for over an hour. So at some point she was pronounced deceased, but there's no evidence that she was deceased when Todd found her in the shed.
Did you find any?
She was unresponsive, but no indication she had already passed.
Did she ever come to or become responsive again based upon your review of the evidence?
Counselor, that would be a question for the emergency room doctors who worked on her. I don't know.
Although you just testified to what they found or how long they worked on them, right?
I believe that my recollection is they worked on her for about an hour before they pronounced her.
But you can
so my sense is that they believed that she was alive. I mean, I have a lot of experience with individuals who are either declared deceased at the scene because it's apparently obvious they're deceased, or as soon as they get to the hospital, they're declared deceased. That's not what occurred here. So
she wasn't declared deceased at the hospital?
Not immediately. I've had, hundreds and hundreds of cases where offenders or where victims are declared deceased as soon as they arrive at the emergency room. But that was not the case here. So I don't know. There's nothing that says that she was deceased, and people believed, because they were working on her, that she was still alive.
Sure. Mr. Saffre, we were provided a list of your prior testimony in the last 4 years. I believe that lists, is it 2 trials that you've testified in? Or 1 trial?
I don't have that list in front of me, but whatever, it should be accurate, yes.
How many trials do you believe you've testified in the last 4 years or so?
Trials, probably those 2.
And
if there's 2 on there.
You also list depositions, I believe, for a grand total of 4 items or 5 items or so. Does that sound about right?
Yes. If I provided that, that's accurate, yes.
And it isn't in criminal cases specifically, right?
Well, they're civil cases, but they're all related to criminal, typically homicides. So I have to evaluate all of those homicide scenes.
Sure. And how much were you paid for this case?
Well, not enough. But I did a lot of the work pro bono after. I got paid initially, but I've done a lot of work pro bono, and I've not, just because, they don't really have the money, and I think it's worthwhile to provide my insight in this case.
Thank you, but that didn't actually answer my question. How much were you paid on this case?
I think $10,000.
Okay. And how much pro bono work have you done?
I do a lot of pro bono work for various organizations. All my work for the VDOC Society is pro bono. I do other cases pro bono. So.
Right, but I'm asking specifically about this case, Mr. Saffre.
This case. Right. A lot of my time, probably 25 to 30 hours has been pro bono.
Is your hourly rate $500 an hour for a 4-hour minimum?
That's my testimony for depositions, but my hourly rate is $400 for analysis and case work.
And how many hours have you done of work on this case?
I don't know offhand.
Could you ballpark it like you did for the 25 to 30 hours of pro bono work?
60 to 70 hours of work. It's been over, I was retained in July of 2022. So it's been, 3 years?
So 60 to 70 hours of work total, or inclusive of your quote unquote pro bono hours?
That's probably total.
I don't have anything further. Thank you.
Any redirect?
A few questions, Your Honor. Mr. Saffre, I'm going to show you what's been marked as Exhibit 281. While this is being pulled up, this is a multi-page document, and I'm going to have my colleague scroll through Exhibit 281, and I'm going to ask you if this looks like a true and accurate copy of your CV and your report in this case.
I'll object, Your Honor. This isn't in evidence, and certainly it includes hearsay statements and testimony, and we would, have that evidentiary fight later on, but we've been having it for quite some time, so as the court knows, we would reiterate our same objections here. Also, this report's unsigned, out of compliance with the rules of civil procedure, and therefore not properly affied to. But we would raise our standard objection. Thank you.
All right, thank you. I guess, counsel, were there additional arguments that you wish to address at a later time with regard to this exhibit, or?
I'm just showing him a CV, Your Honor. That was my intention right now.
Okay. Well, go ahead with that for now.
Yes, this is my CV. When I update my CV, I change the date at the bottom of the pages, so it shows January of 2025. I think I had an article published, and so I updated the CV, but that's accurate.
All right, and Exhibit 281 is a true and accurate copy of your CV and your report in this case?
Well, all I can see is the CV at the moment. But yeah, that's my CV, yes.
Let me know when you've had a chance to determine whether this is a true and accurate copy of your report.
Okay. Yes. I was looking for the date on it. appears to be yes.
Your Honor, we can...
It's 57 pages. If it's 57 pages, then yes.
All right, and Your Honor, we can take up any other issues with this document at a later time.
All right, we'll do that.
You can take the document down. You were asked some questions about medical issues in this case. Did you review reports from a forensic pathologist and a biomechanical engineer related to the Mullis case, Mr. Saffre?
I did.
And do you defer to the expert opinions of those experts in their respective fields?
I do.
And do you, when you indicate that you are not able to determine sort of when you are not able to determine exactly how events might have transpired here, do you intend to offer an opinion about whether a biomechanical engineer could offer opinions about that topic?
No, I don't.
I mean, are you disputing any of the opinions of pathology and biomechanical experts in this case?
No, I'm not.
You were asked some questions about the rake and some of the things that occurred after Ms. Mullis was found in this case. Was Mr. Mullis removing the rake from Ms. Mullis, was that an attempt, is that behavior that's consistent with staging a scene?
No.
Why not?
Again, the purpose of staging is to create a scene that law enforcement can attend. The investigators can attend and then see the scene and make their assessments on the adulterated, changed scene. Because again, you're trying to create a new motive for the crime, and then that's what you want. That's what you want law enforcement to see. So you don't create it and then destroy it. And everything that I saw is consistent with him rendering aid. It's consistent in their statements as well, with him rendering aid.
If there is testimony in this case that Mr. Mullis's daughter, who was a minor, saw the corn rake in the shed near the time that Ms. Mullis suffered her injuries, would that change your opinion that Todd Mullis was the only person to reference seeing the rake in that area?
Objection leading.
Overruled.
Yes, I knew that the kids played in the shed, and Tristan suggested at one point that maybe they had moved the rake, but I don't think anybody knew where the rake was. It was never identified in a particular location, except I think Todd said a couple weeks prior he put it against the shed door.
And are Todd's statements about where he left the rake, are those consistent with someone staging the scene, as you've testified about?
Objection, vouching an improper testimony for or through prejudice.
Sustained.
I didn't ask you your opinion about how you would evaluate the cause of Ms. Mullis's death, but the state did. So I'll ask you, did you reach a conclusion about what the likely cause of Ms. Mullis's death was?
Objection, improper opinion testimony. He can't come to a pathological diagnosis, Your Honor.
They opened the door to this, Your Honor.
Did you want to respond to that, Mr. Rudin?
Sure. We didn't have a report. We didn't ask for his report to provide us an ultimate testimonial determination. Ultimately, the question was, isn't the basis of your report in the ultimate conclusion for you to decide whether or not this was a homicide or an accident? That's what's cited at 56 and 57. When he was coming to a determination, he said he couldn't speak to a manner of death specifically because he's not to undermine the pathological opinions or the medical opinions here. Simply put, that's the basis of that testimony was to object on the basis of that he is not an expert who can provide that and render an opinion.
Yeah, I guess, Ms. Thompson, that's how I understood the witness's answer as well. If you understood or believe something differently, you may respond, but Otherwise, the objection sustained.
Well, just to make clear my point, Your Honor, I mean, the state asked him a number of questions about why he did not determine this was a homicide. We don't intend to offer him as a medical expert. He's not a medical expert. But given that they inquired about those conclusions, it's our position we should be able to inquire about his conclusions as well. But I understand the court's ruling, and I'll abide by it.
Thank you.
One moment, Your Honor. I think just two more questions, Your Honor. One is, Mr. Saffre, you were asked some questions about whether you're testifying as a profiler in this case. Are any of your opinions in Mr. Mullis's case based on your experience in profiling possible criminal defendants? I don't know if the witness was able to hear me. It might have been because my mic was off. I apologize. Let me just read. Mr. Saffre, I assume you could not hear my question. I apologize. I think my mic was off. So let me restate.
No, I didn't hear it. I didn't hear anything.
Apologies. Let me restate that question. You were asked some questions on cross about whether the opinions you were providing in this case were based on your experience as a profiler. And my question for you is, are any of the opinions that you're offering about the Mullis investigation opinions you're offering in the context of being able to profile potential criminal defendants?
No.
I don't have any other questions, Your Honor.
Any recross?
None needed, Your Honor.
All right. Thank you, Mr. Saffre. It appears that your testimony is complete. I'll go ahead and end the Zoom at this time.
Thank you, Your Honor.
For those of us here in the courtroom, this is probably a good point to take our morning recess. Let's break for about 15 minutes and plan on picking up at 11:20. Court is in recess until then.
All right. They went dark for, that's weird. They just turned off their feed. All right. So let's review. I closed the poll chat. So my question to you was, you live 20 minutes from any help, which is where this farm apparently is out in the middle of nowhere, 20 minutes from any kind of hospital, which means 20 minutes there, 20 minutes back. So you're looking at a 40-minute swing. So if you live 20 minutes from any help, what do you do to help your loved one? So call 911 and wait. So that's 20 minutes plus 20 minutes. So 12% of you said that, and this was 63 votes. So 12% said that. Act to help your loved one. 84% said that. And then do nothing. 3% of you said that. So I guess my follow-up question would be, A lot of you were saying, or I don't know, maybe not, but Todd pulled the rake out of Amy's back and he picked her up and put her in the truck. And some people say, well, at least the state is saying, no, he shouldn't have done that. He shouldn't have done that. That just shows how careless he is. But when I posed that question to you guys, 84% of you said act to help your loved one. Now, granted, that may not mean that you pull a rake out of their back, but 12% said call 911. I should have put another one in, call 911 and help. I don't know. I guess it depends on the situation. Like if somebody falls off a barn or out of a tree and their arm is like that, what are you going to do? But if there's a rake sticking out, or if they've got, they have a farm accident where they get impaled by something, I don't know. That's a tough one. But I want to know who 3% said do nothing. That's really funny. All right, let's see. What Irish Amy? I don't want to bring that up, but what are you guys doing that you don't want to get us in trouble? Yeah, Brad, I'd like call 911 first and then help, depending on what they say exactly. Hey Mona, no one should ever pull anything out of a body. That is true. Although there was somebody, there was that EMT that said there are 2 instances, and I can't remember what they are right now. Therapist, I live way too far away from emergency aid. I'm acting immediately while calling 911. I think if you can, we're the same. We're a good 20 minutes from a hospital. So, of course, it all depends on what it is, what happened. But Trial Junkies United, objection! I thought it was said he could get her out of the building with the rake in her back. He says no, and we've seen those pictures. The rake was 36 inches long, which is 3 feet, I think just shy of 3 feet, maybe it was 30, anyway, let's just say 3 feet, sticking out of her back, so she adds another 6 to 7 inches, so you're looking at a good 40 inches or so, maybe more. And the width of that shed, I think, was the walkway was only 30 inches, so that wouldn't have happened. Yeah, I think he said he tried, and it couldn't happen. Nanar, I would call 911 and help, but how do you give CPR with a rake in a person's back? You can't, even though you shouldn't pull anything out usually. Yeah, that's true. How do you? It's going to come out at some point. Shirley Roth, he said he couldn't get her out of the door. Yeah, that's what he said. Oh, Trial Junkies, I meant couldn't. Oh, that's okay. Let me go back to the original. So I thought he said he couldn't get her out. Yes, that is true. He couldn't. Widespread panic. To me, calling 911 is finding the best way to help. She had a rake in her body. I wouldn't feel qualified to help before I did that. I would call for sure. Yep, Drunky the Bear, rake that was 6 inches in. I know. I mean, technically he doesn't know how deep it is, but that's got to be... And he said he pulled it out and then he tossed it. All right, let's get to the testimony of Mr. Mark Saffre. President of Forensic Behavioral Sciences. He's a death case investigator. He was a police officer since 1977, then a detective. He's been with the FBI, or he was with the FBI, I think he said for 20 years or something like that. So from 84 to maybe 2004-ish. I think he said 20, I'm not sure. Seems like he knows what he's talking about. So he analyzes crime scenes. They talked about equivocal death evaluation. He reviewed initial law enforcement investigations, the autopsy photos, diagrams, interviews, the crime scene. He says that the state says it was staged, but he doesn't believe it was staged. The scene is literally the entire farm area. The injury location is the shed. He says Amy died at the hospital, which is true. Staged is created by a perpetrator to remove evidence or create distractions. All right. You create a new scene that shows a new motive. You're trying to get, the offender manipulates the scene so that law enforcement, looks like, they're overwhelmed by what they're seeing and they're not quite sure what they're seeing. He doesn't see this as a staged crime scene. Why is there a scene in his case? That doesn't make sense. Why is there a scene? My question doesn't make sense. Anyway, his answer was because Amy wasn't deceased and there's an attempt to render aid in 3 locations. Oh, why isn't there a scene? Maybe that's what it is. Why isn't there a scene in this case? Because there were 3 locations of trying to render aid. The shed itself, the truck, and then outside of the truck. They live in the middle of nowhere, and it makes no sense to send your 13-year-old to discover. I think that's when I put up the poll. Todd didn't care what... it doesn't make sense to let Tristan go back and talk to law enforcement. I mean, that kind of makes sense, because if you don't know what your 13-year-old's going to say, right? And then you don't know if like your kids are going to come, and because 2 other kids were on the farm. So if you're sitting there stabbing your wife, how do you know your middle daughter isn't going to come out? Because she was 10 or 11, I think, at that time. If Tristan was 13, I think she's like a year or 2 younger. She could have been out there, and yeah, it's just, I kind of agree with that, but let's see what else. Tristan didn't care what, Todd didn't care what Tristan told law enforcement. Tristan talked to law enforcement a couple of times, and Todd wasn't there, and you're right, Tristan could have said anything and everything. He says a weapon is not a good weapon. You literally would have to escape your son to do this. You don't know about the other children, and it would be risky to be doing this. Here you are stabbing your wife, and then there's your daughter, like, Daddy, what are you doing? If this was planned, it was poorly planned. His words. If you're going to stage this, you have to know where the corn rake was. Todd says he hadn't seen the rake in 2 weeks and set it against the wall. Todd could be lying. I mean, that's the one thing I didn't agree with him on. He's saying all these things, major assumptions, huge speculation. I mean, Todd could be lying when he says that. He didn't see any evidence that Todd was aware of the infidelity. They talked about confirmation bias, and then objection. What is the point of this testimony? I thought that was pretty good from Mr. Duden. That was overruled eventually. I was asked to determine if a manner of death other than homicide would provide a logical explanation for Amy's passing. First thing law enforcement does is separate witnesses. It's law enforcement 101, and I'm like, hello, Canton Police Department, you separate the witnesses. Oh, so aggravating. That is so aggravating that they... Anyway, that's a whole another case. Did you see confirmation bias on the text messages? He said, yes. And basically it was Amy's text in confrontation with her mother-in-law. It appears Amy is talking about Todd, but is talking about the mother-in-law. So then the cross came up, Mr. Duden. So you're not a psychiatrist, you're not a psychologist, you're not, or a doctor. And he was really snarky about that. He came in with the snark, that's for sure. Counselor, you're taking that out of context, and that's not very good of you. It wasn't that, but it was another comment. So killing unfaithful women is a school assignment. Oh, that's what it was about. The Google searches. So killing unfaithful women is a school assignment? He's like, no, you're taking that out of context. Tristan's testimony that Todd was out of his sight for undetermined time. Would that change your testimony? And he says no. The initial interview is the most accurate. And I think, Brad, you're the one that says, well, the initial interview, he could have been lying too. Each time Tristan testifies, does that weigh in as a protective factor? I don't know if you answered that or not. Everything suggests that this was not a staged case. Then he's like, have you ever evaluated Valentin Nagai's reports? And he's like, who? Dude, it's like, that answers my question. Oh, this was a good exchange. Then we get to, finally, how much were you paid? No other experts have been asked, but they asked him, how much were you paid? And he's like, not enough. I do a lot of pro bono work. This was really fun, interesting testimony and snark going back and forth. Thank you, but that didn't really answer my question. It just continues. Ultimately, he says he was paid $10,000, and he estimates 25 to 30 hours were pro bono. His rate's $400 an hour. Whew, again, I'm in the wrong industry. I'm in the wrong business. He doesn't know how many hours, and he's like, well, could you give an estimate like you did, ballpark it like you did your pro bono? And he says 60 to 70 hours maybe. So he's been working on it for 3 years, since July of 2022, I think he said. So, some funny stuff going on here. This exchange, this was a fun exchange. This is why we watch. You just never know what you're going to see. But in these trials, you can sit through days of just mind-numbing, soul-crushing testimony, and then you get a moment like today. It was pretty funny. All right, what are you guys saying? Brat says 25 to 30 hours pro bono, also known as we negotiate a break on my $400 an hour rate. Hey, Tanika, how are you? Good to see you in our chat. Thank you for joining us. Trial Junkies United. Objection! Make sure you teach your minors to ask for a lawyer. They have that right. I taught my husband, no matter what, ask for a lawyer before being questioned. Yep. Julie BME or Julie BME. I'm going to go with Julie BME. I've been saying Julie BME, but I'm going to go with Julie BME. The other children were in the house. That is correct. They were absolutely in the house. Tristan's the oldest. Then there's the daughter who I think is there today, and then there's the youngest son. I have their names written down. I don't recall them right now. Let me see if I can find them real quick. Well, they're still minors, so I'm not going to call them out. We won't call them out. Lily Wayne, thanks for the recap and answers my questions. No problemo. Yeah, Tanika, you're going to run into a lot of people. A lot of people swim between all these streams. It's really cool. I'm glad that you're seeing people in here you recognize. Tanika 2 cents, good to see you. Anyone think he didn't do it? I have so many questions, Tanika. I don't get behind it's an accident, and I don't get behind that he killed her. Okay, so Tanika, there's four possibilities, right? 4, right? And I've done this before, so we'll do it again. 1, Todd did it. 2, Tristan did it. 3, it was an accident. 4, somebody else did it. So what say you? I don't agree with that it was an accident, but I also don't agree that Todd did this. I'm just not seeing that either. The tines were going up, they were going down. The only way he would have done this is if she was on her hands and knees and he was over her and he axe chopped her in the back, then he came around to her front, to her head, and did another axe chop that way. It's the only, and we reenacted it, and that's the only thing I can come up with. It's the only thing. Tanika, the 2 extra puncture wounds make it hard to believe it's an accident. Well, the one going up, the 4 going up and 2 going down. So again, the only thing that could make sense, and we reenacted it right back there, we reenacted it, is if she's on her hands and knees and he axe chops her, because he's 10 inches taller than her, and this blade the handle is 3 feet. So if he's coming like that, he's going to hit her on the head, right? I mean, if this is her head, Todd's like this tall, he's swinging down, he's going to hit her head. He's not going to hit her like that. So the only thing that makes sense is if she's on her back, he hits her this way, then he comes around to her head and hits her that way. That's the only thing in my mind that makes sense. Marley Mom, I can't wrap my head that it was an accident. It's so hard. It is so hard to come to that. I think he did it, and the son was encouraged to get his story straight as per timeline. Widespread panic. But either Tristan is covering for Todd. Oh, they're back. Or he was a part of it. All right. Hold on. Let me get you back into the courtroom. Yeah, Gordon, get the broom out again. We may just have to. Tanika, I haven't been able to explain it using the defense supplied theory, which involves 2 tines staying in while extra holes are made by the same rake in a different orientation. Yeah, let's not forget there were 6 holes, but only 4 or 5 holes in her coat. So how do you wrap your head around that? Irish Amy, do we know 100% it happened on the barn, or was that just Todd's testimony? It was both. Tristan found her, Tristan found Amy, and then Tristan yelled out, and then Todd came. So between those 2, yeah, they were the only 2 there. Well, the kids were there, but for some reason, they weren't involved per se. Hey, Mona, seems totally sus, and why wouldn't he bash a door out to get her out with a rake intact? Yeah, I mean, think about that. There's a 3-foot rake, or sticking out of her back. Well, actually, okay, so she's like this, and the rake is like perpendicular. No, parallel with her. The rake is parallel with her. It's not like it's sticking out. The rake is parallel with her, right? So, how are you going to pick her up, drag her out? I mean, she's going to drag her on her front. I mean, that just seems even more cruel, right? I mean, it's just a no-win situation when you've got, here's her body. Here's the rake, right? How do you get somebody up, right? Because the rake's down by her butt, It's just a no-win situation. It's just a no-win situation, Child Junkies United, objection! But I don't think the ceilings were high enough in that area for him to swing the rake overhead, either with his height. We know the aisle was 30 inches. The height, we're not sure how tall it is. It did look pretty tall. At the next break, I'll pull up a picture of the shed. It looked like it was. It looks like it could be 10 feet, 10 to 15 feet. Not 100% sure about that. We'll have to pull that up. All right. I'll see you guys on the other side of the break.
Please be seated. Ms. Nichols-Cook, additional evidence?
Yes, Your Honor. The applicant would call Lynn White.
All right. Ms. White? Take your time, please. You can come forward and have a seat in the chair to my left.
There's no chair.
Yep, go ahead. Oh,
There's no chair.
our chair disappeared. Well, that's interesting. We can grab one from over here. Thank you. Thank you. All right. If you'd raise your right hand. Do you swear the testimony you're about to give will be true and correct?
Yes.
Okay. You can turn that microphone on in front of you there. There's a button in the bottom center. And then feel free to adjust the chair and the microphone so that you can sit comfortably.
One is lit up there. There you go.
Yep. Okay.
It's lit up. What was the second part about it? I'm sorry.
Feel free to adjust the chair and the microphone so that you can sit comfortably.
All right.
Okay. Ms. Nichols-Cook, whenever you're ready.
Thank you, Your Honor. Good morning, Ms. White. How are you?
Good morning. Very well, thank you.
Can you state your name for the record and spell your name for the court reporter?
Lynn White, W-H-I-T-E.
And Ms. White, how do you know Todd Mullis?
I am his older sister.
And where do you currently live?
Dubuque County.
Did you grow up here in Delaware County?
Yes, I did.
And what do you do for work?
Currently, I am a office manager for a construction company.
How long have you been there?
14 years.
Prior to that, what did you do?
I was a city clerk treasurer for a small town in Dubuque County for 10 years. a neighboring county for 5 years as a deputy clerk, and I also worked in the banking industry for 5 years.
Do you have other siblings in addition to Todd?
Yes.
Who are they?
I have an older sister, Lori, an older sister, Mike, and the 2 younger boys, Pat and Todd.
And Mike's your brother?
Correct.
We've heard some references in other testimony about Lynn and Mike. Would that be you and your brother Mike that people are talking about as far as helping with things around the family farms?
Yes.
And then is Leroy Mullis your dad?
Yes.
Do your parents and your brothers all live close to where Todd and Amy Mullis were living in 2018?
Yes, all within about 5 miles.
And does your family, including your parents and your brothers, do they currently farm?
Yes.
Have they always farmed?
Yes.
Is it crops or livestock?
Both.
Both? In the spring of 2018, do you know who was planting crops?
Todd planted the corn and Mike planted the beans.
And in 2018, do you know who would harvest crops?
In 2018, it was Todd that ran the combine along with Mike.
Can you tell us about your relationship with Todd's wife, Amy?
I was in their wedding. I am the godmother of their daughter. At holidays, we would play cards together, do the dishes together, throw darts in the yard. I would stop on occasion to the farm and just visit.
I want to talk now specifically about the summer and the fall of 2018, okay?
Okay.
Do you remember learning that Amy's grandmother was ill and eventually passed away?
Yes.
Did you learn about any other family issues that Amy had going on that were affecting Todd and the kids?
I believe that her uncle was also in the hospital. He had some sort of brain bleed, and she was assisting her mom in taking care of her uncle.
Do you know if that required Amy to be gone from Delaware County at times?
Yes.
Did you have interactions with Todd and the kids and Amy during the summer and the fall of 2018?
Yeah, I would see them on occasion, yes.
Did you have any concerns about Todd and Amy's relationship?
None.
I want to talk now specifically about November 10th, 2018. Do you remember what you were doing that day?
I was babysitting my 2 grandsons.
Did you get a call that day about Amy?
Yes.
Can you tell us what you did after you got that call?
After I got the call, I assigned the babysitting duties to my husband, and I jumped in the car and I went to the hospital.
What did you see when you got to the hospital?
At the hospital, we went into the family room, and there was some friends that were in the family room along with Todd sitting in a chair. His eyes were red. I could tell he had been probably crying or was upset. And there was, I believe, I'm not exact, but I think that, there was other people in the room, but I don't know who they were.
Okay, no, that's okay. And if I ever ask a question that you're not sure about, please ask me to ask it again.
Okay.
While you were in the waiting room, did you learn that Amy passed away?
They had come and asked Todd to go back to the emergency room where she was at, and when he came back, they said she had passed away.
At this point in time, what was your understanding of what had happened to Amy?
There was a farm accident at the farm, something with the red shed.
Did you help Todd with the logistics and the arrangements for Amy after that point?
Yes.
Did you help him make the funeral arrangements?
Yes, I went along with her mom and stepdad, and Taylor, I believe, also went along to help, and we made the funeral arrangements in Manchester.
After the funeral arrangements had been made, did you learn that there were concerns that Amy's death was not an accident?
When I was going up to the farm, on, I believe it was the 16th, I had called Todd that I was on the way, and he said that he had gotten a call from Sheriff LeClaire that he wanted him to stop in at the office, and they were going to get the file basically kind of wrapped up, closed up, and so we could move on. So, and I don't want you to, I want to make sure I keep asking. So on November 16th, is that when you became aware that there were concerns about Amy's death not being an accident? Yes.
Okay. And so at that point you learned that the sheriff wanted to see Todd. What did you do?
I picked him up and I drove him to the sheriff's office for this interview to get it wrapped up. I waited in the waiting room.
Do you know how long you were in the waiting room while Todd was with the sheriff?
It was approximately 2 to 3 hours at least.
What happened when you and Todd left the sheriff's office that day?
They had told me they issued us, what do they call them, subpoena, and that they wanted to get Amy's phone from the farm. And so we basically drove back to the farm then with just in the car with the subpoena or in our hand. Was reading it, I guess.
Could it also have been like a search warrant?
Oh yes, that's what it was. Sorry.
Okay. At that time, did you learn what investigators thought had happened to Amy?
I'm gonna object. This is calling for based upon hearsay.
Well, overruled. The witness can testify as to her understanding.
When I went into the interview room, Agent Turbot had said that we know Todd did this.
So at that point, in your mind, what are you doing? Like, what are your next steps?
I guess I was in shock, number one. Next step, I thought, where are you coming up with this? Because it was a farm accident. And I was trying to think, who do I call? So,
did you contact an attorney between the sheriff's office and the farm?
Say that again.
Did you contact an attorney between leaving the sheriff's office and arriving at the farm?
Yes.
Were you at Todd and Amy's then when the search warrant was executed on the 16th?
Yes.
How would you characterize your interactions with law enforcement during that process?
After we had given them the phone, they wanted to see the buildings, and when we were walking to the building, Travis Hemesath turned around and said, "You need to tell your brother."
Sustained.
If you can characterize it without repeating what someone said to you, as far as was it hostile or angry? Was there a lot of back and forth? What do you recall observing and being a part of?
Can you re-ask that again? Sorry.
Yeah. When the search warrant is being executed on the 16th, can you describe for us what was happening? Were officers also talking with you and Todd?
I'm going to object, Your Honor, on hearsay and backdoor hearsay, even if we're cabining it where it's not saying specifically what they said, it's based upon those statements and observations of those statements.
Yeah, I mean, I think that question is probably inviting hearsay, Ms. Nichols-Cook. I'm not sure if maybe you can rephrase.
Let me try, Your Honor. Thank you. Would you characterize the interactions that you had with investigators aggressive towards you?
Same objection, Your Honor.
Overruled.
You can answer.
Yes.
After the search warrant was executed, did you help Todd make any adjustments to the funeral arrangements for Amy?
Yes. We spoke with Bob Sabers, and we just plain asked him, do we want to wait on getting the cremation process delayed if there's going to be issues?
I'd like to show the witness Exhibit 310, just the first page. Let me know if it pops up on your screen.
It's not popping up for some reason. Just a second here, counsel.
Your Honor, may we approach the witness and show her one of our screens?
You certainly can. It's not acting like it's connected at all, so I'm not sure what the issue is.
Ms. White, do you recognize that document?
Yes.
Can you tell us what it is?
It was the letter that was drafted to by Leonard Funeral Home in order to have them delay the cremation.
I object on hearsay on this letter. The letter's not in evidence, and it's signed by Mr. Mullis, so it's hearsay.
Okay. The objection's overruled. The answer will remain in the record. And you had not offered it yet, correct, Ms. Nichols-Cook? All right.
Ms. White, did you help Todd write this letter?
We talked to the funeral home, and the funeral home director is the one that wrote it.
And did you?
I was on the phone call.
It?
I was on the phone call with the funeral director at the time, yes.
Did you type up this letter?
I don't remember.
Have you seen this letter before today?
Yes.
And is what you've seen today a true and accurate representation of the letter that you helped Todd prepare for the funeral home?
Yes.
Okay. At this point, we would move page 1 of 310 into evidence.
Mr. Bakke?
With the caveat, we're just talking about page 1. I have no objection on foundation, but I would object on the same hearsay grounds that it's signed by Mr. Mullis.
.310, page 1 is admitted. The objection's overruled.
Thank you, Your Honor. Ms. White, I want to move on a little bit and talk about, you mentioned Bob Sabers earlier. Is he an attorney?
Yes.
Were you involved in hiring counsel or representation for your brother Todd?
I assisted, yes.
Is Mr. Sabers one of those attorneys that you met with and hired?
Yes.
Do you recall when you first hired Mr. Sabers?
After talking to the lawyer on the way back to the farm, we also asked him, it was not the type of law that he had or practiced, so he suggested some names. We're like, who do we talk to? So he suggested some names, and we called Bob. Actually, I called Bob, but...
Thank you. Do you recall the date that Todd was arrested for Amy's murder?
February of 2019.
And at that time, Did you let Mr. Sabers know about the arrest?
Yes. I was at work and I got a phone call from my brother Mike, and so then I proceeded to call Bob and find out what was going on.
So at some point, did another attorney become involved in representing Todd on these charges?
Yes.
Do you remember his name?
Jake Firehelm.
And while these attorneys were representing your brother, was Todd in the county jail?
Yes.
And at times, was he also moved to the Buchanan County Jail?
Yes.
What was your role with the attorneys while they were representing Todd?
I was kind of the middleman as far as communications. I was the gopher to find information to get to them.
Were you in communication with Todd while he was in the county jail?
Yes, he would call.
How often would he call you?
Oh, probably at every 2 or 3 days, every day. It just depended on the week.
When you said you were the middleman or the person, does that mean you were asking the attorneys questions?
Yes.
And were you also then providing them information or answers to their questions?
Yes, correct.
Was Todd asking you questions?
Yes.
Were you able to give Todd any answers?
None other than they're working on things, because I didn't want to get into details over the phone.
Why was that?
The phone calls are recorded.
Do you recall Todd writing notes and letters to the attorneys while he was in jail?
Yes.
Would you also then get copies of those from the attorneys?
I would get the originals from the attorney.
I want to show the witness a prior exhibit 233.
Oh, and it came up. It popped up now.
Thank you. Ms. White, this exhibit has several pages, but looking at the first page, do you recognize it?
Yes, it's one of Todd's letters.
And we can scroll slowly for you. Does this appear to be a continuation of Todd's writing?
Yes.
Okay. What about this page?
Yes.
And the next one?
Yes.
And the next one?
Yes.
And on this one, do you see a date at the top?
Yes, August 29th, 2019.
Based on your recollection, is this before the criminal trial?
Yes, that was in September.
Okay. Next page. Is this also Todd's writing and a continuation of the prior letter?
Yes.
And same question here.
Yes, continuation.
And we've covered all the pages in that exhibit. So can you tell us a little bit about what types of questions and information Todd was looking for while he was in jail?
Well, he kept asking if we were going to have the scene recreated, if we could possibly get experts on what they were looking for.
I'm going to object on hearsay grounds. Party opponent to himself.
Overruled. You may continue with your answer.
Can you repeat the question, please?
Yeah, I'll ask you another question. Todd and you have conversations before he went to jail about, what would happen if he was arrested?
Yes.
And did you get kind of chosen to help, be a voice for him?
Yes.
And so when Todd would communicate with you, either via letter or phone calls, would you take concerns that he had to the attorneys?
Objection leading.
Overruled.
Yes. I would call them and just call them like every day. What's going on? What are we doing?
And did you also send them emails?
Yes.
At any point, did they start sending you updates about the case and what was happening?
They would send phrases along saying we're working on things and just tell me they were working on things. I mean,
what was your understanding of what that meant, we're working on things?
Objection, it's based on hearsay and vague.
Sustained.
What did you think was happening at that time?
Objection calls for speculation.
Asking for her own understanding and to explain the actions that she takes next. It's not asking her to repeat any out-of-court statement for the truth of the matter. It's what she thought was happening.
If you can clarify as to the time period, the witness may answer.
Ms. White, during the time after Todd's arrest, before his trial, when you would have conversations with the attorneys and they told you they were working on things, what did you think was happening?
I'm going to object again on hearsay and speculation.
Overruled.
well, they shared things with me, and in sharing things with me, I would ask them what's being done about materials they had shared with me. If they were working on things, we kept telling them too, it's an accident. What are you finding out? Are you going to recreate this? What are you doing?
Okay. And you said they were sharing things with you. What types of things were you getting?
I got just about everything. Medical examiner reports, her medical records. I've got police reports. I got the Celebrate information. That's what I can recall right now.
And I know earlier I briefly asked about your work history, but to clarify, that didn't include any investigative training or experience?
No.
Any cell phone, Celebrate
No.
type of experience? Do you remember talking with anyone else besides the attorneys directly during this process, during this time period of leading up to trial, that worked with the attorneys?
Yes. I talked to the secretary for Jake Firehelm, and the two of us collaborated on a lot of the issues that we had in front of us. I would do things on the Celebrate. I would work up reports and figure out how to get everything in line, and then I would call Christy and ask her if she saw the same thing, and told her basically, she's like, how did you get that? So then I went through the steps on pulling up the Celebrate information and told her how to basically connect everything together, and then she would let me know that she was going to show this to the attorney, Jake, and share it with Bob.
Did you ask her if they had an expert to review the digital?
I told her, I asked her, I said, we need somebody to look at all this. We need a computer guy to do this. But when she asked, well, how did you get that report? I would explain to her and tell her in detail how I come up with the report I had.
I'm sorry, I didn't hear your objection.
Hearsay. Thank you.
Overruled. The answer will remain in the record.
To your knowledge, as the person who was representing your family with these attorneys, did either attorney ever consult or hire an expert to review the evidence that you were getting copies of?
We asked several times, but I was not informed anybody was hired, and I kept inquiring, who do we have?
In the weeks leading up to the trial, did the attorneys ask you or the family for any information or assistance?
Yes, we provided them with drone footage of the farm a few days before the trial. We provided them with pictures of the barns, the area where Todd was working at. We provided, actually, Bob had emailed me asking me if I would draft some questions about...
Objection, hearsay.
Sustained.
It's okay. So was this the first time they'd asked you to do things to help with their representation?
Not the first time. I offered, what can we do? How can we help? What do we need to do to help in the accident? To get information out to show.
And then did you write questions for witnesses?
Yes.
And provide those to the attorneys?
Yes, since the attorneys didn't have a background on some of the people on the deposition list, they just said, can you give us a little background on these people and maybe draft some questions as to what to ask them in the deposition.
Had you ever hired and worked with attorneys before?
Hired, I've got a tax attorney. Other than that, through my work at the city, we had a city attorney. At my job now, we have attorneys there. I don't hire them, but I work with them. For a personal
matter, for a family matter like this?
Not for a family matter like this, no.
Did you have concerns that you brought up to the attorneys before trial?
I kept asking them, are you going to talk to Todd about what's going on? Are you in communications with him? Does he have everything he needs as far as what's going to be presented? Several times we talked.
What was your impression after phone calls with Todd about whether he had information about what the attorneys were doing?
I'm going to object that this is based on hearsay or backdoor hearsay.
Sustained.
I need just a moment, Your Honor.
Sure.
Would Todd communicate frustration to you?
Yes.
Same objection.
I'm not asking for a statement. It can't be hearsay if it's not a statement. So I would...
Overrule. The answer will remain in the record.
Were you able to discern why Todd was frustrated?
Yes, he would state that the attorneys would... Sorry.
Objection, hearsay.
I didn't hear that, sorry.
Without telling me what Todd would say, could you discern, what it is you needed to do next?
Objection, this is backdoor hearsay.
I'm asking for her actions, what she did next. So it's not truth of what Todd said, it's the effect it had on her and what she did.
The objection's overruled. Ms. White, just be careful to talk about what your actions were and not what statements were made to you, okay?
Okay.
All right, you may proceed.
The actions that were taken was to get a hold of the attorneys and see what was going on.
So you were asking more questions?
Yes.
And would you also send them emails?
Yes.
Did they ever ask you to review pleadings before they filed them?
Yes, they would send me drafts and I would help them with some grammar and punctuation, that type thing, yes.
Prior to trial, did you ever learn that the attorneys were not going to pursue an accident theory?
No.
Did you attend the criminal trial?
Yes, every day.
Were you present in the courtroom during the defense opening statement?
Objection, relevance.
Overruled.
You can answer.
Yes, I was.
What was your reaction to the opening statement?
Objection, relevance.
Overruled.
Shock and dismay, wondering where it came from.
During the trial, did you attempt to speak with the attorneys?
Yes.
Did you ask them questions?
Yes.
Did that include wanting to know what the plan was for the trial?
Yes.
If you had been informed before the beginning of the trial that counsel was going to concede Amy's death was a homicide, would you have done anything?
I'm going to object as calls for speculation and relevance as to her thoughts of what the trial strategy was.
Sustained.
Ms. White, if you had been informed or made aware about counsel's opening statement, would you have taken any action?
Yes.
What would you have done?
Objection. This is relevance into what her actions or statements or conduct would have been in response to trial counsel's trial strategy is not relevant.
Right. Sustained.
If you had known, would you have gotten new counsel for your brother?
Same objection.
Sustained.
Were you ever consulted about conceding homicide?
Same objection.
Overruled. No.
To your knowledge, was Todd ever consulted?
Objection. There's no foundation that she was aware of every conversation between trial counsel and relevance, even if there was.
Overruled. I was not aware of any communications on that, no.
Do you recall talking with Todd after he testified at his trial?
Yes, he called us on the way home, I believe.
Was he upset?
Yes.
Were you upset?
Correct.
At that time, in 2019, did you think Amy's death was an accident?
Say that one more time.
At the time of the trial in 2019, did you think Amy's death was an accident?
Yes.
Have you learned anything that's ever changed
No.
your mind? Did you meet with the attorneys after the trial?
Yes. We met with Jake. Bob, we didn't meet with him, I don't believe.
Did you ever learn that Todd now thought Amy's death was a homicide?
Objection based on hearsay or backdoor hearsay. If she learned that information, it's based on statements that were made to her. So even if it's cabined in such a way that it's not reflecting the statement, it is based upon the information that was learned that is hearsay.
Sustained.
Ms. White, has your brother always maintained his innocence to you?
Yes.
And then I think I just have maybe one thing I forgot to ask you in the beginning. Do you recognize this glass fixture that I'm holding up?
Yes.
Can you tell me what it is?
It's a light cover that they use in the hog buildings to go over the light bulbs.
Did you provide this to the attorneys for
Yes.
the current attorneys for Mr. Mullis?
Yes, I did.
And did it come from the hog barn at the Mullis farm?
Correct.
Your Honor, at this point we would move Exhibit 275 in.
Any objection?
Not on foundation, just on relevance.
275 is admitted.
Your Honor, I know it's noon, and I need to queue up perhaps my last exhibit. So if the court could give me a minute, or if the court wants us to come back after lunch, I'm fine either way.
We can keep going, I think, if it makes sense to finish up your direct.
Ms. White, do you remember, we were talking earlier about talking with Todd after he testified at his trial, if that would have been September 22nd, 2019?
Yes.
And I know you mentioned earlier that the calls, when Todd would call you from the jail, they would be recorded. So do you remember him expressing frustration about the questions he was asked on cross-examination?
I'm going to object on hearsay again.
So far, as long as you're not responding to specific statements that were made, the objection will be overruled. You can answer.
Was he expressing frustration?
Yes.
And Your Honor, I would like to play this call that we're talking about. I believe it's a prior consistent statement of Mr. Mullis, and so it would satisfy an exception to any hearsay objection to aid Ms. White in her testimony.
And I anticipate I know which jail call this is, Your Honor, and I would object that this is not a prior consistent statement that was made under oath at a prior court proceeding. This is simply a jail call between Mr. Mullis and his family member. It falls directly within hearsay. Mr. Mullis, of course, could have testified about his own recollections, but he can't testify through another witness.
Which exhibit is this?
It's in the jail calls, I think 375, and there's 686 jail calls in there by my count. So.
Ms. Nichols-Cook, I guess, as far as the issue of it being an exception or not, any further record you wish to make on that?
Yes, Your Honor, I think that there was a lot of cross questions about Todd's testimony at trial and whether he conceded it was a homicide in his testimony. And this phone call comes directly after that, in which Mr. Mullis explains that he still thinks it's an accident, but he didn't know how else to answer that question on cross-examination. And it is consistent with all of his prior statements to law enforcement that her death or her injuries were the result of an accident. And that is what he continued to tell his family and his attorneys throughout the process.
Okay, again, though, if this is Mr. Mullis's statement that you're using, correct, not this witness's?
Yes.
All right. So we'd still have a hearsay problem then, it sounds like.
I do think it could also fall under the residual hearsay exception.
And just for purposes of the record, there has been no notice of residual hearsay exception being intended to be used at this trial.
So at this point, I'm not thinking that this would be admissible.
Okay, I can move on, Your Honor, and ask a final question. Ms. White, have you continued to support your brother throughout his legal proceedings?
Yes.
No further questions.
Okay, Ms. White, you may step down for now.
Your Honor, I think I can keep this very brief if that's acceptable.
Absolutely, certainly. You may go ahead with your cross.
Thank you, Your Honor. And I guess good afternoon now, Ms. White.
Good afternoon.
It's just so we're all clear, you are Todd's sister, right?
Yes.
And it's fair to say you love your brother.
Yes.
You care very deeply about him.
Yes.
And that you did everything you could in your power to assist him with his defense.
To keep communications between him and the lawyers and just to keep the ball rolling, yes.
And you still believe in his innocence and want to see him be successful in this action. Is that fair?
He is innocent.
You were asked a couple questions about helping review pleadings. Do you remember that?
Yes.
Would an example of that be, so there was a bond issue, I believe. Were you asked to review specifics about how much land Todd owned, for example?
I had to give background on that, yes.
So that would be an example of specifics you were providing to the attorneys to put into the pleadings?
Just a small portion.
You are also aware, or are you aware generally, that if an attorney talks to you, if you're not the client, that it would waive attorney-client privilege?
I was not aware of that.
Are you aware of it now, generally?
I did not know that, no. I believe Todd had permission with the attorneys or told the attorneys that they should be talking to me as well so that I could be his middle.
What their strategy was going to be to pass on to the family or to Mr. Mullis?
Never.
No further questions.
Any recross?
No, Your Honor, and just for the record, we would release Ms. White from our subpoena as well. And thank you.
Thank you.
Okay, thank you. Now you may step down, Ms. White.
All right, thank you.
All right, let's go ahead and take our lunch break at this time. I think, counsel, based on our earlier discussion this morning, Ms. White may be our last in-person witness. Is that correct, at least from the applicant's side?
Yes, Your Honor, that's my understanding.
Okay. I know that we have several witnesses that will be presented through their deposition testimony or by stipulation or other agreement. And the state may need an opportunity to confer before there's any final plan as far as presentation of in-person testimony. I don't know, counsel, were you in a position to commit to that at this time?
Yes, Your Honor, I can commit. As the court and both parties know, we have been attempting to ask our questions during cross-examinations to streamline matters, so we will have no additional witnesses to call at this time, just the depositions and the evidence that has been presented.
Okay. So I guess more for the benefit of those who are here observing, there would not be any additional in-person testimony. The remaining matters that need to be agreements regarding the remaining witnesses that we have to talk about. I know that counsel is continuing to work on some agreements as far as how that testimony would come in specifically for the court's consideration. So we'll certainly pick up with that after lunch. And then once we've concluded that, I'll provide both parties with an opportunity for some limited oral closing argument, and both parties will then also have an opportunity to submit brief written legal briefs to the court to identify any legal authority that they believe would be particularly helpful. So we'll discuss deadlines for that as well when we come back this afternoon. I anticipate that our arguments and our discussion regarding the evidentiary issues will take some time. I would propose that both parties have up to 15 minutes for any oral closing argument that they wish this afternoon. I'll also provide the applicant an additional 5 minutes for a rebuttal closing since it is the applicant's burden. So we'll plan on concluding with that at the very end of everything else that we need to do this afternoon. Anything of a housekeeping nature that we should address then before we break for lunch on behalf of the applicant?
Nothing, Your Honor.
Anything on behalf of the state?
No, Your Honor.
Okay, let's plan on picking back up then at 1:30. All right, I'll see you back here then. Thank you.
All right. So they're breaking for lunch, and they'll be back at 2:30 Eastern, 1:30 Central, 2:30 Eastern. So let me pin that. Court will be back at 2:30 Eastern. Aw, thank you, OnlyFan. Appreciate the membership. Macy Combs, come on down. You were gifted a membership by OnlyFan. Whoop, whoop. All right, let's go through our recap of testimony after the break. So Lynn White came on the stand. She was defense or applicant's witness number 11. And as we just found out, that's going to be the last in-person witness. They're going to do closings this afternoon. Sounds like they're going to be done, which is great because we need some Monica Cementilli time. All right, Todd planted the corn, Mike planted the beans. She's the godmother to the daughter. She was in the wedding of Todd and Amy's. She talked about Amy's grandmother who was ill and eventually passed away. Her uncle, Amy's uncle, was in the hospital with a brain bleed. Amy was gone during this entire time, which we found out, I think, for like an entire month. Amy just wasn't around, which is what it is. And yet, Lynn still didn't have any concerns about Todd and Amy's relationship. November 10th, which is the day of said accident, or however you want to say it, incident, she was babysitting her two grandkids, and she got a call about Amy. She didn't say who called. Not sure who called, but anyway, she got a call. Her husband took over the babysitting. She jumped in the car and drove to the hospital. She went to the family room, and there were some friends in there. Todd's eyes were red. She says she thinks he was crying. The doctors asked to talk to Todd, and he walked out, and when he came back, that's when they found out that Amy had passed away. She was told it was a farming accident. She then said she helped with the funeral arrangements. After the funeral arrangements were made, that's when she became aware that Amy's death was now being said it wasn't an accident. On the 16th, Todd was called to say law enforcement called and wanted him to come into the office. So she drove Todd to the sheriff's office to get it wrapped up. She was in there for 2 to 3 hours, and we saw that interview in the trial. Then a search warrant was issued for Amy's phone, and they gave them a search warrant, I guess, and then they drove back to the farm with the warrant in hand. Agent Turbot told her at that point, "We know Todd did this." She was in shock, and she asked, "Where's this coming from?" She thought it was a farm accident. Then the law enforcement came to the farm, and they were trying to get some testimony in, and this is where we first heard about backdoor hearsay. And then finally, the question was able to be asked, "Would you characterize law enforcement as aggressive?" She said yes. She wanted to delay the cremation if there were issues, if there were going to be issues. She met with Bob Saper, and she's the one that hired him. Todd was then arrested in February of 2019. Mike, who is a brother, called her at work to tell her about Todd's arrest. She then goes on to say she was the middle person for the lawyers and Todd while he was in the county jail. Todd would call almost every day or every other day. They talked a lot. They ended up having 686 jail calls. And I think Monica had over like 1,000 or something like that. Details, didn't want to go into details because the calls were recorded. So she knew about the jailhouse calls being recorded. She got chosen to be the voice for Todd. She took concerns of Todd to his attorneys. She called and sent emails. They kept saying, we're working on things. She asked if they were going to reconstruct this. This was an accident. Are you going to get any experts? And she says they just kept saying, we're going to work on it. She got the Celebrite info. She got reports from the medical examiner. She got law enforcement reports. So she had access to all of this stuff. She asked several times who was being hired as experts, and she never heard back from Todd's lawyers. She said, Lynn said they provided drone footage, pictures of the farm. What can we do to help? She kept saying, what can we do to help? What can we do to help? She even wrote questions for the witnesses because these lawyers didn't have a background on them from their witness list. So, for the depositions that they were giving, she had to write questions for them. I mean, again, going to ineffectual counsel. Why was Todd frustrated? That was an objection. Actions that were taken. Get a hold of the attorneys and ask what's going on. That's those actions that she took. She was even sent drafts and helped them with grammar and punctuation. I mean, she's now a secretary to these guys. I mean, come on, man. I don't know. I've heard so much now about ineffectual counsel, and I think Todd needs a new trial. That's just where I stand. I'll put it in I'll do a poll when we come back from lunch. Never heard about them not pursuing the accident theory. She was shocked and dismayed. Asked questions and spoke to the attorneys during the trial. She wanted to know what the plan was. If counsel was going to concede the accident, would you have taken any action? She said yes. Were you ever consulted about conceding homicide? She says no. She then actually identified the light fixture. They showed it up earlier, and earlier I thought they said this is a representation of this light fixture. So Amy was on a bucket, I believe, and she was taking these light fixtures down, cleaning them up because flies get in there, and putting them back on. So they were covering these light fixtures in the hog barn, and she got a little dizzy, woozy, whatever. I think she may even step down. And Todd and Tristan were like, "Hey, if you're not feeling well, why don't you go into the house, go rest?" Amy did not do that, so Todd then eventually said, well, if you want to help, go into the shed and pull down the pet carrier for the kittens, and at least you can help us. If you want to help, you can help us do that. So that's where this light fixture comes in, and they said Lynn identified it, and she's like, yes, that's the light fixture that we use in the hog barn. Mentions 686 jail calls. She continues to support Todd to this day. Then Cross came in. Is it fair to say you love and care deeply about your brother? Yes. She tried to keep communication open between the lawyers and her brother. He asked, do you feel, that he's innocent? She's like, he is innocent. Were you aware of any client-attorney privileges? She said no. And then on redirect, it was like, well, did you know anything about the strategy that was, was any strategy provided to you? And she said no. So she didn't break any client-attorney privileges. And then we found out no more in-person witnesses, up to 15 minutes for closing for both sides, and then an additional 5 minutes for rebuttal. And they'll be back at 2:30 Eastern, which is another hour for us on the East Coast. That's 1:30 Central, 12:30 Mountain, and 11:30 Pacific. So there you go. All right. What are you guys talking about? OnlyFan. Why was Amy out in the farm in the first place, really? She wanted to come out and help. It was her choice. I think she had the procedure a couple days before. I think she was tired of bed rest. I think she just wanted to come out and help. Florida PI Sam. I understand her advocacy, but she was not the client he was. I have not filed this case as you all have, but I have a lot of issues with family interference in cases. Fala, thought it was the same day. I don't think so. I don't think it was the same day. God, no. There's no way. I don't think it was the same day. Hold on. Let me check. November 6th was her procedure. This happened on the 10th, so 4 days later. So November 6th was the procedure. OnlyFan, I would just vegetate. Yeah, so the 6th, 7th, 8th, 9th, 10th, it's day 4. She was probably getting a little stir crazy, maybe. So I'm just reading. Okay, so Amy got down from the bucket and braced herself against the feeder. Says she felt dizzy. Tristan asked first, then they both asked, is this something we should be concerned about? You're going to get hurt. Why don't you go into the house? Then told her to go get the pet carrier, put it in front of shop, and go in the house. So Julie B. Me, if you're normally a busy person like Amy, it's hard to stay down. I agree. I'm the same way. Deanna, Todd should have taken a more active role in this case, not his sister. I think he was trying, right? I think he was trying, but Shirley Roth, a little antsy doing nothing if you're used to doing stuff. I agree. Especially on a farm. I mean, work is never done. You're never, ever, ever done with your chores. With there's always something more to do. Irish Amy, my mom is a nightmare patient. When she cut through a tendon on her thumb, ow, she insisted on having dinner before going to A&E, and I caught her mowing the lawn. 30 minutes after we got her back. I get it. Oh my God. I'm assuming she insisted on having dinner before going to the hospital. Is that the emergency room? What is A&E? Educate me of the ways of the Irish. I want to know what A&E is. Brett, I'm not too concerned that the defendant's sister wasn't read in. She should have been told directly why there were limits to what they could tell her. Accidents and emergencies. All right, cool. A&E is us language. I gotcha. A&E is accident and emergency. Cool. Thank you, guys. I appreciate that. Little Miss, accident and emergency. Thank you for that. Well, I love the fact that, like, you know, UK, they say, you know, going to hospital or going to university, you know, whereas Americans say going to the hospital, going to the university. I like the fact that. So, did you go to uni? Did you go to university? What university? Well, we say, what university did you go to? But then we say, did you go to, whatever. Julie Schwartz, the procedure she had was not really invasive and usually recoup in a few days. Yep, here we say the ER. Yep, the emergency room. Yeah, Lily Wayne, we learn something new every day. I agree that. I agree as well. Care Bear, how are you? Thank you for joining us. Appreciate it. Sherry, morning. I'm still finishing up Monica. Well, we're going to pick up on Monica as soon as this trial is over. Right now we have it scheduled for 6, and we're going to do day 20, which was Friday. So we're hoping Todd ends so we can actually catch up with Monica, because I think this week is going to be the week we see Austin. Irish Amy, nightmare. We had to pry her away from the pickles and making extra potato options. And was she slicing? Is that what happened? She cut her tendon. Lil Miss, when someone is in jail, it's hard to have visits with counsel, so I can see family stepping in to help. Only fan, you Americans just cut the fluff from the Brits. No, actually, we add that the. Instead of saying university, we say the university. Or going to hospital, going to the hospital. All right. Deanna says, I thought Todd didn't want to go over some evidence with attorneys because it was too difficult for him. I don't remember that specifically. I don't remember that. That he didn't want to go over because it was too difficult. Yeah, I don't recall that. Where did you get that? It would have been from testimony by Mr. Firehelm. I don't recall that. Yes, Brad. Or if not a hospital, we have urgent care, emergency stuff, emergency-ish stuff. I've been to one of those. Irish Amy, yes, she was carving the turkey and just kept going, oh God, while there's blood spurting all over. I can see your mom like, and then there's this blood. Your mom literally put blood, sweat, and tears into that turkey. You're going to eat it. Fala, his attorneys had no interest in looking at the evidence. I don't like the fact that they didn't call any experts, you know. And I remember during the criminal trial, Aaron and I were like, why didn't they call any experts? Why aren't they refuting the UTC? Why aren't they refuting Travis Hemeth's testimony? They didn't bring in one witness. And I remember us watching that, and we're like, why are there no experts to just counter, just to give reasonable doubt? Only fan, Irish Amy, your mom is gangsta. That's one word for it. God bless her. Tell your mom we said hello. All right, guys, I am going to break. I've got some leftover Indian food I made last week even. I got to finish it up. I made a spinach mushroom. I sauteed the mushrooms, took them out, put spinach, onions, bunch of spices, blended that up, put in some yogurt. So that's what I got. That's what I have waiting for me. Aaron made some rice, so I'm going to go grab that. One more, Julie Schwartz. He may have done it, but based on this information, he deserves a new trial, even if the outcome is the same. I agree, Julie. That's where I stand. I know it's expensive for the state and taxpayers and all that stuff, but I would give him a new one. Irish Amy, ooh, sounds delicious. Yes, I love my Indian food. Krista Limited Edition, how are you? It was during the attorney's testimony, I believe. It was in the letter between the attorneys. Todd didn't want to read the testimony because it upset him. Gotcha. Cool, thank you. Spinach and cottage cheese is awesome. Yeah, I did yogurt. I do have some cottage cheese. I could throw that on top. I made some tzatziki. That's the way we pronounce it. Tzatziki. And I usually put that on top, but I don't have any. I have to make some this week. But I'm going to throw some cottage cheese on top instead. So, a spinach. Shirley Roth. Yep, right on. All right, guys. Thank you. I'm going to put you back. I'm going to put you back here. We'll put you back here. We'll play some music. Cue up the music. And I will see you guys in like 45 minutes or so. All right. I am back from lunch. How are you guys doing? Court is still at lunch, scheduled to be back in about 10 minutes. What are you guys up to? Green-eyed cat, how are you doing today? Pratt says, I agree with the FBI guy that you can't know every single detail of what happened, but I just can't account for the 6 punctures in those positions without a second person involved. I've tried. Love and 2 limes, how are you? But what about the 6 punctures? Green-eyed cat, I feel like my impressions are different because I only listen most of the time. Lots of people dislike the state attorney, but I think he's great. I'd take him any day over the giggles from Todd's attorney. Hey, AG4981, thank you for popping in the chat. A little behind, but I agreed with the death investigator. To me, he said what makes the most common sense. These are the thoughts I've had for years. Have to put it all in context, not cherry pick. Therapist you know is at On Guard with Walmart. Oh, are you going to Walmart? Are you on your way to a Walmart? All right, Ken Rosenberg, interesting and possibly feasible chat experiment. Have one half watch a short bit of testimony with audio and video, and the other half only audio, and compare impressions of the witness. Ah, there you are. About to walk into Walmart. All right. On guard. Green-eyed cat, we are doing just groovy. Currently walking the aisles of Walmart. And you're listening to us? Are you doing a Monica Cementili walking around the Target? Looking at your phone? Stay away from the M aisle. Yep. Stay away from the M aisle, or wear a hat that will block you from the cameras. That's funny. I like your little on guard. On guard. So while we wait, a trial that we wanted to cover, Robert Crimo, the third, Robert Crimo, or Crimo, I'm going to go with Crimo. He pled guilty in the July 4th, Highland Park, July 4th parade shooting. Pled guilty to all accounts. So he is not going to trial. Duh to listening, not duh for doing harmonica. Yeah, Pammy, I was fighting you back. On guard. Oh, here, let's get your moment of Super Bowl here. There she is, little sweet little girl. Oh, yum 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 yum. Oh, oh, bless you. Oh, bless you. Oh, I woke up Super Bowl. Hi. Hi, hi, hi. You gonna say hello? Meow, meow. Did I drop food on my shirt? Did I drop food on my shirt? You gonna say hello? Meow, meow, meow. Yo, meow, 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 meow. She's usually so talkative. Meow, meow. Of course, now she's not. When you want them to be talkative, they are not. I should have let sleeping cats lie. All right, into the lap she goes. All right, in you go. Yes, our beautiful mascot. Pammy says, bless you, widespread panic. Just finished my lunch and chores. Did I miss anything? Not at all. Pammy says, bless you, Aaron. Little Super Bowl emojis. Pammy, she knows you want her to meow. I know. And she's gone. Yep, of course she's not talkative. I woke her. Yep, I agree. I agree. And she's back into her little spot over there, which isn't a bad thing. So let's see, if they come back at 2:30, they're saying 15 minutes for closing, 5 minutes for rebuttal. That's 35 minutes. They may be done by 3:30 or 4 East Coast time. Oh, Polly, hi. You want to go out? Out you go. Ready? Out she goes. Polly has left the building. Hey, Nan, how are you doing? Hope your Monday is going well. Polly has a admirer in Pammy. She was out all night last night. We were not happy. We don't like it when she doesn't come back in. It was 45, which isn't too bad, too cold, but it's more like there's coyotes, there's packs of dogs, there's other cats, you know. Brat says, in court time, like football time, will those 35 minutes take an hour of real world time? Maybe. Shirley Roth, moved my stove, cleaning behind it, also smashed my head and cut my fingers. Ouch. Take it easy. Please be careful, Shirley. Widespread panic. Pretty Polly, you didn't let us know she was in the room too. I didn't know either. I fed her and then I just heard this little squeak behind me. Meow, meow. Little squeak. Nanar says all good. Cool. All right. We are waiting for court to come back. They should be back any minute. Hellcat, thanks for coming back in. Therapist you know is wandering the aisles of Walmart right now. Oh, Tammy and KS, that was your nickname as a teen, Squeak. We call that the Super Bowl because when she was young, she would squeak. She'd be like, me, me. So we called her Squeakers. But now Polly really, really squeaks. Oh, Little Miss, any strange pop-pops in the store? Hello, Just Shamrock. How are you? Good to see you. Yeah, what are pop-pops? What are pop-pops? And hopefully you're not referring to gunshots. What's a pop-pop? All right, it's 2:31 here on the East Coast. We are waiting for trial to come back in. I might as well, it's black screen. It's not like we're going to miss anything, but you never know. We'll just do that. Just in case they come back on us and we don't know. Because they like to do that. They like to just come flying back in. Suppose I could do that. So Todd and Amy Mullis. Has this judge been prompt? They usually have been. Oh, and there they are. Yeah, this judge is usually pretty prompt. Oh, Krista, what happened? You got deleted? Oh, Krista, you got too many. You know the deal, man. So you say hello again, everyone. I'm working, sort of migraine, blurry eyes, major shift in our weather. Hope everyone is well. Sorry to hear about your migraine. Brat is prepared with his due. Pop is what you called mother-in-law's dad. Yeah, that seems like a grandfather thing, right? Pop was what you call your grand. Yeah, that seems to be. It wasn't on purpose, Krista. I know. But I hope your migraine goes away. That stinks. Somebody else had a migraine. Was that Mel? Mel, didn't you say you had a migraine yesterday or something? Those are the worst. There's supposed to be some really nasty weather, Krista. Speaking of weather, you said a change in your weather. There was supposed to be like a major storm brewing for the plains, heading east today and tomorrow. I heard that there was going to be a major outbreak of severe weather in our plains today, which I guess is like Kansas, Nebraska, Oklahoma, Arkansas. I think they're supposed to be getting hit. Hey, Valeria, how are you? Good to see you. How are you doing, Valeria? Thank you for joining us. Who is this guy standing up? Oh, he's talking to the attorney. Okay. He must be like, I think he's a camera guy, maybe? That guy in the burgundy shirt talking to both sides of the aisle. They have not started yet, OnlyFan. Tammy and Kay asked, no rain yet in Kansas, at least not where you are. Are you supposed to be getting weather? I thought I saw. Brad, is he a tech guy? Yeah, maybe seemed to be wiring up Junior. Yeah, I thought he might be. Yeah, he might be the AV. So they get 15 minutes each for their closing, with an additional 5 minutes for rebuttal. So I would assume the applicant, which is Todd, would go first. And the additional 5 minutes would be for the applicant. Tammy and Kay asked, we have a chance of rain tomorrow or snow. Yikes, who knows? Yeah, it's one of those, it's that time of the year, right? March, April. It's like March is always one of those transitional months. It could be 70 one day and 30 below the next. It's just one of those days. Oh, look at the former Drakeites yucking it up there. Oh, so is Miss Cook. Notice Mr. Duden is not enjoying. Oh, no, there he did chuckle. But he's not engaging in any of the banter there. It's Mr. Bakke there. At least it's not a tornado. Yeah, that's coming. I know you live in Tornado Alley. That's coming, sadly. Just like us hurricanes, you know, it's just not. It's not a matter of if. It's just a matter of when. Brat, someone needs to put together a montage of shopping in the Red Room aisle, clips from trials. Yes, they do, Brat. Do you want to tackle that assignment? That's a great concept, Brat. So I wonder if there's anybody on Amy's side, which would be the state side. We see, obviously, Todd's side. I wonder if there's anybody that's for Amy. I would think her parents would show up, right? And didn't she have a brother? Does she have? Yeah, I thought she had siblings. Julie Schwartz. So after this, I wonder how long it's going to take the judge to reach a decision. We were talking about that at lunch. I'm not sure if she rules like immediately or if she has to go back and weigh everything. Like, is she already like ticking things off? I think, right, Florida PI Sam, there's like charts they have to follow and point systems, and you know, the judge just can't say, I'm giving you 20 years. You know, they have to go through this kind of checklist to make sure criteria is met. Widespread panic. Could you do that for us? Sure. We're going to assign that task to somebody else. Oh, we got to zoom in. Julie says, Julie Schwartz, she probably has an idea but need to review. But is she supposed to be like a juror, not to make up your mind until after you hear all the evidence, which we have, and then I guess now closing arguments? All right. Seems like court is in session.
Please be seated.
See you on the other side.
We'll go back on the record. Just before lunch, both parties rested in terms of calling live witnesses. However, I think at least the applicant has additional witnesses to identify by deposition. Is that correct, counsel?
Yes, Your Honor, I believe they're on the exhibit list, and if the court would like, we can go through them.
Yes, let's do that, please.
Exhibit 204, Turbot 2019 deposition.
Okay.
They believe that both of these have already been submitted.
Yeah, we did some of them maybe at the beginning.
Yes.
Yeah. There's 258, Hemisath 2019 deposition.
All right, and you show both 204 and 258 as having been previously admitted.
Okay. And then, Your Honor, 301 is TRM video deposition in 2019.
And that was previously admitted.
Okay. And then 316, 2024 deposition of Peggy Munson.
.316 was previously admitted.
317, deposition of Jonathan Turbot, 2023.
.317 was previously admitted.
Your Honor, is it okay if I just read a few of the next numbers to verify?
Certainly.
318 through 326 should all be depositions taken in 2023 of witnesses. I think the 323 would be one the state would want to talk about.
Yes, I agree with that, Your Honor.
That we want to talk about it?
Yeah, that we would want to talk about 323.
Yes. And I do not show 325 as being admitted.
And that would be the additional one that the parties have agreed upon.
All right, thank you.
And then, Your Honor, just to verify, 327 through 337 are also depositions. And I don't believe earlier we admitted 337, as that was Mr. Thomas.
I'm sorry, counsel, can you tell me those numbers one more time?
327 through 337. Just to clarify.
My notes show that it was admitted, but either way, we have no objection to that.
Okay, and that's what my notes show as well, that those would have been part of a stipulated group from Tuesday of last week. So,
And then the last of the depositions should be 338 through 344, and I believe we've already all agreed and admitted those.
yes, I show that those have all been admitted.
And 346, and 352 got left off that page.
I show both 346 and 352 as admitted.
And then 355.
355 is admitted.
So the only one we would be asking to admit that the state's objecting to it this time is the deposition of Jake Firehelm from 2023, marked as 323. Applicant recognizes Mr. Firehelm did testify, but his deposition had to be utilized multiple times during his testimony to refresh him or to correct his testimony, and we think it's appropriate at this time to ask the court to admit it for the proper weight of what it was used for.
Counsel?
And the state would object to the admission of the deposition. And I would just note for clarity of the record that this was a discovery deposition. I believe it was taken before the state even had the benefit of receiving discovery. Not that there was any problem with that, given the timing of when it occurred, that was to be expected. However, given the timing, the fact that it was a discovery deposition, it, in the state's opinion, does not make sense to admit it. And as Mr. Firehelm testified in his testimony here on Friday, confirmed that he did not have his own file when he had that deposition. I believe the parties were able to adequately impeach or refresh his recollection based on his deposition, so his testimony should remain as what he gave in court.
Any further argument in support of your request to admit 323, Ms. Nichols-Cook?
Your Honor, I think our goal here is a complete record for the court to have, and it is additional sworn testimony that Mr. Firehelm gave in addition to the affidavit that he signed and was shown, and I believe the deposition will assist the court in evaluating his credibility and his testimony this week.
323 will be admitted.
Thank you, Your Honor. Your Honor, I believe the parties have an agreement as to Exhibit 371. This is a DCI Google search comparison chart created by Roman Gamble, and we would seek to admit it.
I show 371 as having been previously admitted.
I believe it was referred to during Sheriff Hemeseth's testimony. However, in any event, we have no objection to it. I believe he laid sufficient foundation for that.
Okay. If it wasn't previously admitted, it will be at this point.
Your Honor, I know in our last witness we talked about 375, the jail call records. We would still move to admit for the court's consideration just the September 22nd, 2019 phone call recording that is within that exhibit. It might be more of an offer of proof because of the objections that were made to its admission, and ask that it be admitted as an offer of proof.
375 was the number? Okay.
There's many phone call recordings within that electronic exhibit, and we're just specifically asking for the September 22nd, 2019 call. I apologize, I don't have a better way of identifying it for you.
Okay. I guess to the extent it's being, or the court's being asked to consider it as an offer of proof, any additional record you wish to make on that point, Mr. Bakke?
Yes, Your Honor. The state objects to the admission of the jail call for the reasons already stated and addressed in the record, hearsay among others. I guess I'm confused what the purpose of admitting it for an offer of proof would be at this point when no additional witness testimony is expected. So we would object to its admission.
Well, the court will consider it as an offer of proof just so that it is part of the record for purposes of any further proceedings in this matter.
Thank you, Your Honor.
Are you going to refile that?
Just that once.
All right. And I know we have some other exhibits to talk about. Ms. Nichols-Cook, does that address all of the additional witness testimony that was coming in on behalf of the applicant through deposition?
Yes, Your Honor, there's one topic regarding Mr. Saber's deposition. The exhibits used in that deposition are separate exhibits on this court's trial exhibit list, and I know the state had some objections to some of those, and I don't know if the court would like me to identify which ones I believe are referenced in Saber's deposition for the record, or what's the best way to do that?
That's probably the best way to do it if they're not all contained within the same exhibit. So Mr. Saber's deposition is which number?
320, what? 323? 325.
Okay. And then the exhibits that go with Mr. Saber's deposition.
That would start at 219, Your Honor.
Okay.
220. 223. Yes, 223, I'm sorry. 234. 235. 236, 237, 238, 239, 240, actually through 246, and then 247, through 252. And 278. I believe those are all the ones referenced in that deposition.
Okay, so some of these are on my list of previously referenced exhibits that were problematic. I don't know if those are the ones that you're referring to, or if it is some of the newly identified exhibits that are troublesome. I guess Mr. Bakke or Mr. Duden, did one of the two of you wish to identify which exhibits are objected to, or do you need a minute to confer?
Your Honor, our objection is only to what we had previously expressed during our pretrial motions as well. that we would ask that those exhibits and depositions be considered for their weight because they do contain hearsay, rather than more so for the truth of the matter asserted. But we would also note that 252 has been previously admitted as a part of 233. I believe it's the later pages of 233 or in the middle section. Either way, for clarity of the record, we don't have an issue because it's cumulative and the court's already admitted it. And subject to the state's objection on the use of hearsay testimony in those exhibits, we don't have any objection to those being included here.
All right, so uh, 325, the deposition of Bob Savers was previously admitted. And then as I understand it, 219, 220, 223, 234, 235, 236, 237, 238, 239, 240 through 246, 247 through 252, and 278 will also be admitted, subject to any prior orders of the court limiting those exhibits. And it's possible that at least one of those was already previously admitted, I guess.
Yes.
Okay, all right. Okay.
Okay, thank you, Your Honor. I think after that it takes us into exhibits related to expert testimony. I believe those would be Exhibit 274, Dr. Bowley's report, 279, Dr. Weck's report, 285, Dr. Nye's report, 276, the portion that is Dr. Hammer's report, 281, Mr. Safarek's report, that we would move to admit those. I understand the state has raised a concern that they could be improperly used to bolster or vouch the experts who did testify. However, expert witnesses are allowed to rely on other information and data under Rule 703. This is something they testified they normally do in the course of offering an expert opinion. The data in 703 is not hearsay. It's also, this is a bench trial, and again, the court can afford their proper weight to these exhibits, and it goes to more than just what Dr. Hammers and Dr. Nye testified to. It shows the prejudice of counsel's errors at the trial and provides that context for the court and the record of what is being discussed and reviewed. So even the reports don't have to be admitted for the truth of what they're saying, but it's for their use under 703.
Response on behalf of the state.
Yes, Your Honor. As the court knows, we have always objected to the inclusion, especially of the reports and information present in this case from non-testifying experts. Those reports are being offered, in our opinion, either for a vouching purpose or for the truth of the matter asserted, and therefore are hearsay that would be impermissible for inclusion of the record here. But for the use of those reports, subject to the state's objection, we have no issue with the court taking it under advisement if they would like to evaluate it, given that prior discussions have occurred for for instance, of Dr. Nye's first report as a mere report of vouching to the credibility determinations of Dr. Bowley or Boley, who did not testify here. In subject to our hearsay objection, I don't think there's any way around considering them for their truth value. So we would ask that they remain to be excluded in subject to the court's determination, but no further arguments necessary on these because we've maintained our objections from the very beginning and before we came to trial.
The expert reports will be admitted subject to those objections, and my final order will clarify, I guess, to what extent, if at all, the court considers the opinions of the experts. Well, and let me clarify. I'm going to defer my determination of admission of the expert reports, and my final order will indicate to you what is admitted, because I do need to review those in more detail to determine if I can separate out any portion of the report that should not be admitted. And primarily that deals with the information from Boley. Under the case law and under the rule, it really is the Boley report that is problematic. I don't think that there is any way of interpreting the inclusion of Boley's report in Dr. Nye's report, for example, as anything other than a conduit for getting Boley's opinion in when it otherwise wouldn't come in. And that is not permissible under our rules and under our case law. And so I think it can be excised in all likelihood without damaging or taking away that portion of the work that Dr. Nye did, certainly from her second report. But I will clarify for the parties in a written ruling that in fact that is what I have done. And so with regard to the experts, that will be the plan that we follow with those reports.
Can I get clarity on just which exhibit numbers? I was a little slow in writing them down. I apologize.
Sure. So Boley, I believe, is, her separate report is identified as 274. Let me just double check my numbers here. Yeah, 274. Wecht is 279. Nye is 285. Hammers is 276. And Saffre is 281.
And then, Your Honor, my friends in appeals would be remiss if I didn't ask to do this, but regarding the jail call that was submitted for the offer of proof, if I can read the name of that file into the record just so everyone is clear going forward what we were talking about, if there's no objection.
Go ahead.
My records show it is called 687-308-34_. 09-804_09-22-22-08-12-58. And there's more to it, but I believe that should be sufficient to identify.
Thank you for that. I'm sure that'll be helpful for the court too in locating the particular call to the extent I would need to. So. Okay. Ms. Nichols-Cook, anything else that you wish to address with regard to exhibits?
Your Honor, I know that we all agree the underlying record is a part of this proceeding. I think we've realized we did not file the motion for new trial sentencing transcript from September 4th, 2020. And we would like that to be a part, of course, of the record. And if there's no objection, we can upload that today. And it would be like 978, I think.
Any objection to that, counsel?
No, Your Honor, it's already part of the record. If it's easier to have it filed here, no objection.
It doesn't make any difference to me. I mean, if you wish to have it marked as a separate exhibit in this file, that's fine. But certainly by statute, the underlying case file would be considered part of this record. So it's up to you, counsel, if you wish to have it marked separately.
I think so, Your Honor.
Okay.
Just for clarity, what's 977?
An email that a fire home was shown?
So 978 was the number you said you would use for that? Okay, and that will be admitted.
Your Honor, the next thing on my list is to address the photographs that were submitted as exhibits. Obviously, we did not show or utilize every photograph that had been proposed. And I think that we can identify a handful of them that we know were shown to witnesses that we believe should be a part of the record, but we also don't oppose the admission of additional photographs or the group exhibit in its entirety if that's what the court would like.
So I show, for example, 500 through 580 as having been admitted, which I believe are all photos. And I know that we didn't, or the witness didn't talk specifically about all of those, but I do show that they've been admitted. Also 600 through 655, which I believe are all photos. And again, I know they weren't all specifically referenced, but I do show that they were admitted.
I believe 700 through 734 are DCI photographs. We would have no objection to those. I believe only 731 has been admitted thus far, but for what it's worth, we would not object to the 700 series.
Okay. Did you wish to offer those then at this time?
We would offer those then.
Okay. All right, so 700 through 734 will be admitted. I know, I think there are probably some other photos sprinkled in through there, but those are the big groups that catch my eye.
Your Honor, I had 3 in the 900 series that related to Dr. Nye's testimony, and I'm happy to just identify those 3 for the record if that works.
I show 929 and 938 as being admitted.
Okay.
976, I think we were arguing about.
And I think for clarity, the photos are 800 through 975, so the third one that I have down is 890.
And I show 890 as being admitted.
And we're not seeking the admission of the rest of the Dr. Nye photos. We would move to admit Exhibit 976 related to Dr. Nye's additional records, with the understanding that these would be for the courts to assist the court in understanding the testimony and as additional offers of proof, if not directly admissible on their own.
Any response, counsel?
Yes, Your Honor. The state has, conveyed fundamental issues with the 14-page supplemental information that was included with Dr. Nye's testimony. Certainly, I think the parts that are worked with or were worked with during her testimony fall on pages 12 and 14. 12 being her calculation page that was referred to, and 14 being the citation page or references page. The state has no issue with the admission of pages 12 and 14. The rest is a little bit wonky, given that it is aspects or portions of other admitted exhibits, not Dr. Nye's work, but kind of like a drop document that was used for things that she'd want to refer to later. So we would object based upon hearsay and the inclusion specifically, as it wasn't in her expert reports, but would simply ask that the court accept the 14-page document subject to the state's objection and reserve ruling on it like the other expert report information specifically. Given that it also includes portions of other experts' reports, like Dr. Hammer's, Dr. Boley, and other outlier information or demonstratives.
Right, 976 then will be treated in the same fashion as the, I guess the substantive expert reports will be. additional exhibit issues to address on behalf of the applicant?
Your Honor, we are waiting a signed stipulation declaration regarding exhibits 390 through 396. There'll be 2 declarations from court administration that to authenticate and lay the foundation for those exhibits. We would ask to be allowed to move those in upon receipt of those declarations.
Any objection to that on behalf of the state?
We don't know what the full declarations look like, so we would ask that the court allow us to defer. We don't anticipate there being any issue with the declarations, but some of the information was still kind of outstanding or highlighted within the judicial branch's declaration page.
Okay, I guess on that issue then we technically probably just need to leave the record open to receive those.
Sorry, Your Honor, we just received the signed one, so maybe if we circle back to this in 5 minutes.
Certainly, that works just fine. We'll do that.
Your Honor, I just had a couple left on my list to make a formal record on that the applicant does seek to admit the affidavit of Carrie Piersbacher as identified as Exhibit 215, the affidavit of Jake Firehelm in 224, the affidavit of Donald Pottabaum in 379, as well as a transcript of the November 10th, 2018 911 call identified as Exhibit 294.
Response on behalf of the state.
To the extent, I do apologize that I was looking at the portions for the declarations. If my understanding is we're asked about the affidavit specifically?
Yes, of Carrie Piersbacher, Gerald Firehelm.
Mr. Pottabaum.
And then the transcript from the 911 call.
Yes, Your Honor, we would renew our objections to the admission of affidavits. I believe on Monday the court made clear on the record with regard to Carrie Piersbacher that affidavits wouldn't be admitted for the testimonial purposes that they've been sought for. Especially for Mr. Pottabaum, for instance, we believe that testimony would be uncrossed and relatively inadmissible or misleading for the court, so it would be objected to on those grounds. We believe each one constitutes hearsay, and we already addressed, I believe, Ms. Piersbacher's affidavit, but we did allow, without objection, the admission of her report. So her affidavit was unnecessary, but we would renew our objections to the remainder of the affidavits. As for the transcript of the 911 call, our position is, as we've said previously, we object to it on a hearsay ground, specifically that the record speaks for itself. The 911 call was subject to the Court of Appeals opinion. It was subject to being played in the underlying case for the trial, and certainly the court has engaged in some portions or prior rulings in the summary judgment phase or summary disposition phase here as it relates to those 911 calls and potential enhancements. Should the court wish to receive the certified transcript not for its truth value but to assist or clarify the testimony of, say, Mr. Firehelm, for instance, we have no issue with the court receiving that subject to our objection and that it wouldn't be considered for its truth of the matter asserted.
The three affidavits that are being offered will not be admitted. Exhibit 294, I believe, is the 911 transcript. will be admitted.
I believe that is all I have, Your Honor. And then we do have a list going of demonstrative exhibits that we identified during testimony. And we would like perhaps a little time to provide that to counsel and then present them.
Yes, I guess there was a question between the parties, the best way to file those. In past cases I've seen where the court files them as court exhibits, but beyond that, we don't have any problem with making a complete record. Our friends on the appellate side will appreciate the clarity.
Yeah, I do think they need to be made a part of the record, but it is important to distinguish them from the actual exhibits, and so I'm fine calling them court exhibits or demonstratives, just so that we're careful to keep them separate. They were all, I guess, paper, which helps, but if you would like to gather those up, and you can provide them to me if you would like before we leave here today, and I can make sure that they get into the record. That's fine.
Thank you, Your Honor.
For purposes of closings, given that the demonstratives have been referred to fairly repeatedly as the same letters that cross over with the state's exhibits, referring to them as demonstrative D or whatever would be probably the easiest way of going forward. Is that okay with the court as well?
It is, yes.
Thank you. And we'll refer to ours for purposes of the record too, with the court's permission. I think making a good record here is probably the easiest part. We refer to our exhibits as exhibits A, B, C, D, F, G, H, and I believe. But we did not admit Exhibit E, and we have filed them as PCR-A, etc., simply because the underlying record, the other ones were unavailable. So we would ask that the court recognize or accept that while we may speak to our exhibits or the exhibits that have been admitted here as A, B, C, etc., that those exhibits be understood to mean PCR-A or B, etc.
Certainly, and I did note that in the electronic record and understood the correlation and the reason why they were labeled that way.
Certainly. Thank you, Your Honor.
Anything else as far as exhibits or clarifications for the record on behalf of the applicant?
Just one moment.
Sure.
We have executed a stipulation that the state will file here in a moment regarding Amy Bernau, and I think Your Honor, can I verify that Exhibit 314 medical records, which I don't believe was an objection to, was admitted?
I do not show 314 as having been admitted.
I likewise do not show it as admitted. I don't believe we have an objection to them, especially considering that we stipulated on Dr. Thompson's deposition and files. However, given that it is medical information and has unredacted information as would be expected, we would ask for that to be at a heightened security level. I believe a level 1 would be adequate.
Okay. 314 will be admitted.
I don't believe I have anything else, Your Honor.
Your Honor, I'll ask it this way, and I believe there was some question about security levels on a few of the exhibits. I believe most of the problematic ones weren't offered, so it should be minimal, but I don't know if maybe additional time before they're formally admitted, if the parties can, or if Mr. Mullis's counsel already knows if there's any additional ones that might need a heightened security level.
So other than 314 that we just talked about, I can tell you that the only other one that I have a note on right now as needing a higher security level is 400.
Your Honor, I think the applicant would have no objection to any of the medical examiner photos being filed at a high security level, or Dr. Thompson's photo collection.
We have no objection with that. The 500 and 600 series photos. I do note, for whatever reason, it appears that they might not have been filed at a heightened security level in the underlying case. It's my opinion that had to have been an oversight. I don't know if that's something we can also resolve while the parties are all here, but
I think that if everyone is in agreement, I can probably address that.
Your Honor, the applicant would have no objection to increasing the security level of the photos in the criminal case. I think additionally there's a couple of photos in the 200s that were used in depositions that have been admitted that would also require a higher security level, and perhaps the autopsy report. So like 225 through 229.
As well as the State's Exhibit B, which is an autopsy report as well.
Okay, I've got notes on those. The security level will be addressed in the court's exhibit management order. I believe that that directs the parties to file any additions or corrections within 10 days or something to that effect. So certainly if the parties identify any additional changes that should be made with regard to not only the exhibits that are identified as having been admitted, but also the security levels that are established, certainly feel free to bring that to the court's attention so that changes can be made. I know that it's easier for clerk staff and certainly less work if it can be done up front rather than later on. So.
And I do, just as I was scrolling through this list, I do recognize there's probably going to be additional, such as 216, the EMT report has date of birth. So maybe, so we do this once, if the court would be willing to defer filing of the exhibit order so the parties have time to go through the exhibits just to identify any confidential material, or attempt to.
That's certainly fine, counsel. If you'd like to confer and send me an email within the next day or two, we can wait to file that. That's not a problem at all.
Thank you.
And Your Honor, I can confirm that the stipulation filing reached between the parties has been electronically signed, but also filed for the court's review and agreement here regarding Miss Amy Bernau's testimony.
All right, thank you. And then, I guess maybe so I don't forget, I'll come back to the declaration and exhibits from court administration. I think that was 390 through 396. Has everybody had a chance to look at that, or do we need a little more time on that one?
I believe the 390 through 396 portions for the jury management questionnaires or jury-related information has all already been redacted and provided, and the state has no dispute about the admission or foundation of that testimony or those exhibits being admitted here.
Okay. So the 390 through 396 will be admitted if I don't think they were previously.
397 census.
I don't.
Your Honor, I'm sorry, there was one more related to the jury discussion. It's Exhibit 397. It's a U.S. Census Bureau report. We would ask the court to take judicial notice of that exhibit.
Any objection to that, counsel?
Your Honor, I don't think we have any issue with the information in that exhibit being accepted as census information or anything like that. To the extent that the court wants to take judicial notice of that information, then we have no dispute or really any issue with it being admitted as census information.
Well, yeah, and I guess I understand the request to be that I would take judicial notice of it rather than admit it as an exhibit, so I'll notice it, so.
Thank you, Your Honor.
Yep. I'll jump over to the state maybe for now. Any witness stipulations, exhibit issues on behalf of the state? I have not necessarily cross-referenced my list of notes as far as outstanding exhibit issues. Maybe for fear we'll discover more, but I think we've hit certainly the major things as far as exhibit reports.
I guess the only clarification, just to make sure that your list matches ours, that it's all except Exhibit E has been admitted. Then I believe we have covered everything as far as my notes reflected.
Have the parties compared notes as far as which exhibits of the applicants they think have been admitted?
No.
But we can do so when we verify our final list and information. We can either do it now, Your Honor, or we can do it at the time we do the protected information, but probably for purposes of closing it might be easier just to do our closings and then verify that information after the fact, given the numerical changes and things like that.
I mean, it seems to me like it would be prudent just to be 100% certain that everybody's on the same page as far as what exhibits have been admitted before we leave here. I understand it's tedious and not super exciting to sit here and do that on the record, so we definitely don't need to do that. But maybe before you leave here today, and also just to make sure that my list appears to match as well, would be a good idea, because obviously there are a lot of exhibits in this case. But with that said, if you think that we have addressed all of the kind of lingering cleanup issues that we needed to, if you would like maybe a short break before closings, we could do that and then come back and wrap up.
Yes, Your Honor, the last thing I had to put on the record was that the court's order regarding summary judgment, any motion to reconsider or enlarge would be due for this Friday, and the applicant would just request an extension to consider that.
The state's position?
If I recall correctly, the summary order regarding the court's positions on summary judgment said a longer order was forthcoming. Should the court be open to it, as well as applicants' counsel, I believe that the state would just request the opportunity for that deadline to toll until after the court's full ruling speaks to it, so that the actual questions and issues can be responded to specifically in addressing the court's specific decisions.
Yeah. I kind of like that idea. That maybe seems to me to be the most efficient use of everybody's time. Counsel for the applicant, does that work for you guys?
No objection to that plan, Your Honor.
Okay. So we'll plan on that approach, and just to have less dates to keep track of, maybe, if nothing else. Yeah. So, okay. All right.
And then one last matter. I believe the court indicated brief deadlines would be addressed. Do you want to do that now or at the end?
We can talk about that now. Do either of you have a request as far as how long you would like to submit final legal authority to the court? I think I mentioned earlier, I'm not contemplating anything extensive. And really, unless you're telling me you are wanting something more substantial, I'm contemplating a one-shot 5-page limit focusing on legal authority that you believe is on point and controlling, and any particular testimony or evidence from the depositions that wasn't on the record these last few days, because I do have extensive notes from the testimony that we've been listening to. So if there's something that you want to draw my attention to from those depositions, obviously I will read them, but if there's something that you want to highlight, you could do that within that 5-page limit. Yeah, go ahead.
It's my understanding from what the court indicated previously that the court would consider the legal briefing on these issues that we already laid out in our summary.
Absolutely, right, which is part of my rationale in suggesting a very limited final brief. Both parties have spent a significant amount of time already briefing the legal issues in this matter. All of that is in the court file. I have access to it, I've reviewed it, familiar with it, and so I don't know that rehashing all of it again is useful for anybody or a good use of your time at this point. So certainly to highlight the most critical pieces now that you know how the evidence has come in is fine. But to go much further than that, I don't think is particularly helpful. So,
Your Honor, at this point, I think my proposal, unfortunately, would be to ask for 30 days, in part because part of our team is out of the country later this month, and I just to make sure that we could get all of our thoughts together and complete that. I know 5 pages isn't that much, but
April 4th is a Friday. Otherwise, March 31st would be exactly 4 weeks from today.
I think we could probably...
Your Honor, there is a major conference that I think a number of people on applicant's side are attending, that the first day of which is April 4th, and I have some professional responsibilities at that conference. I can't move, unfortunately. I don't know if it'd be possible to make this do the 8th instead.
The 8th of April?
Yes.
Yeah, okay. Does that date work for the state?
Is the court seeking simultaneously filed?
Yes, yep, just a one.
Yes, I feel that. Yes, the deadline works wonderfully.
Okay. So April 8, 2025 by 4:30 p.m. Okay, if we plan on coming back at 3 o'clock for final arguments, 15 minutes, and a final 5-minute rebuttal.
Thank you, Your Honor.
Okay, I'll see you then.
All right, somebody help me out there. What was April 8th at 4:30? I didn't quite catch, what was that last little bit there? Is that when she's going to make a decision? What was the April 8th? Somebody help me out. Who was paying attention? 30 days. Part of the team's going to be out of the country. Got that. All right, what was the April 8th? What was the April 8th at 4:30? Comment. 5-page summary. Okay. Lily Wayne. April 8th is for their 5-page summary to go to her, so decision will be after that. Okay. Deadline for 5-page. Thank you. All right, so they came back from break, and both parties rested. After calling no more live witnesses, there were a bunch of depositions that they entered, a bunch of evidence, 911 call, affidavits, all evidence in by April 8th. Okay, fair enough. All right, so now we have 15 minutes for both sides for closing and then a 5-minute for rebuttal. So it's going to be applicant, state, applicant. They have to write a five-paragraph essay about how they enjoyed this hearing. Due by April 8th, double spaced. That's funny. Just Shamrock, the 2 polls are very close. Yes. Well, the first one was should he, so that's more like what we feel, and then you'd have said, well, why don't we go with will he? So that's what now we have to get into the head of the judge. So the first one was should he, and that was 60 votes, 61% yes, 38% no. And I popped over to Scott's channel. He had should Todd, so it's really funny. We both had should Todd. So we were at 64 and 36. He was at 67 and 33. But now we're at 61 and 38. That's where we ended up. So I said both of our, seems like both of our chats are on the same page. But now this new, okay, so now a new poll is, will Todd receive a new trial? So now you have to put on your judge hats. Final brief. Cool, thank you. For final 5-page summary / final brief. Thank you, therapist. That is awesome of you. Appreciate it. Final brief. Final brief. Okay. Thank you. Appreciate that. Closings are at 2. That can't be right because it's almost 4 here. Did she really say 2? Did she mean 3? Go check that again because it's already past 2 there. April 8th, 4:30. Arguments 15 final. Motion to reconsider is due Friday. Okay, I'll see you then. She doesn't say. Back at 3 o'clock. Okay. That makes more sense. Closings are at 3. Yes. Closings are at 3. Just Shamrock, I said yes to first poll, so that was should he, but no to the second, so that's will he. The legal standard is a high bar to meet. Yeah. Sorry, sun's starting to get in my eyes here. So let me do a little quick rearranging. Yeah, I don't know. I think, well, we're going to have to see. We'll see what the judge says, ultimately. Marianne B. Question, was part of the argument that Todd is presenting is the fact that he did not want his original attorney to argue? Yes. Yes, because Todd has maintained the entire time it was an accident, and his attorney came right out of the gate saying it was not. She was deleted. And Todd says he never was consulted in that. He never, he didn't. He was always saying it was an accident. And Mr. Furhelm just came right out of the gates in his opening saying that she was murdered. So, motion to reconsider is due Friday. Okay, thank you, Little Miss. Appreciate that. Green Eyed Cat, I voted in support of the new trial so he can get convicted again with the accident defense and all this goes away for good. I think it should go back to a jury, to be quite honest. That's where I land. I think there's enough, whether you believe it or not, Todd never had experts come in to testify for him. And how many times have we watched a trial where it's the battle of the experts, right? I mean, almost literally every trial, it's a battle of the experts. Whether it's psychologists, psychiatrists, accident reconstructionists, medical examiners, whatever it is, there's always a battle of the experts, right? Todd never had that. So just from that standpoint, I would say he deserves a new trial. Bring in these experts, and again, whether you agreed with them or not, that's neither here nor there. But I would say bring in Todd's experts, bring in the state's experts, and let the jury decide. That's where I land on this. Lily Wayne, what is the motion to reconsider? What does that mean? Well, Little Miss, you're the one that heard that and put that up. So could you help us out on that? I didn't hear anything about that. I was paying attention to other stuff. Seagate, what kind of experts who? Well, Dr. Nagai, she came in. She was an expert. She was in day 2. She's a biomechanical engineer. You have Jennifer Hammers. She was a doctor, forensic pathologist. You have Sean Casel. He was a digital forensics network security. Mark Saffre, he was the death case investigator. Lynn White, the older sister. Granted, she wasn't an expert. So I would say at least Valentina Nagai. She reconstructed it. And again, this has nothing to do with whether you believe them or not. I'm just saying Todd didn't have that in his criminal trial. And every trial that I've watched, there's always it seems like it boils down to a battle of the experts. Who are you going to believe? Who are you not going to believe? Okay, Little Miss. Brief deadline is due. Final legal authority, 1-shot, 5-page limit is due April 5th. Okay. Queen Olive Ruth Ann going on third walk of the day. Good for you. OnlyFan, they should be allowed to present their expert witnesses to a jury, no doubt. I'm not sure, Lily Wayne. Little Miss, can you help out on that? Lily Wayne, what's that Friday deadline for the motion to reconsider? Would that be the state to reconsider charging Todd? I can't imagine that. What is that? Seagate 1 sounds like Karen Reed. Yeah, I mean, think back to all the trials you've watched. There's always been, like, both sides always have an expert, right? Just Shamrock. I found the WTF note passed to attorney after opening statement was telling. Yep. Let's not forget that somebody was watching the 911 call on court TV and called up the called up the state prosecutor, said they thought that Todd said, go to hell, you cheating whore, die, blah. And then she used that in the trial. She had transcripts. And if you listen to that, we've listened to it here. I think Friday we listened to it. You look me in the eye and you tell me that that's what you heard, because I will challenge that to the day I die. I did not hear that, and I think that was highly prejudicial. And they didn't bring in a voice recognition expert. They could have very easily brought in somebody and said, that could have said, I'm a bore to you, you eating, you eat my chores. I mean, you could have said anything, but they decided to make their narrative that Todd was guilty. I think that was highly prejudicial, and I didn't agree with that. I remember when I watched that in the beginning, like when Aaron and I watched this when it first came out in 2019, and I'm like, there's no way. That's not even close to what he said. You can even determine what he said. I did hear him say this last time we watched it. We watched it on Friday. We pulled it up, and he's like, come on, like he's doing the chest compressions, and he's like, come on. I heard that. I heard him say that. That was pretty clear, but I didn't hear him say that. So I thought that was highly prejudicial. I thought Hemiseth not getting the UTC timing right, and these things were coming in at 2:30. Oh, okay. Devin was sentenced. That's too bad. Hemiseth was talking about these searches going on at 2 o'clock in the morning, and of course they're like, oh, it was Todd that was doing it. No, UTC, you back it up 5 hours, so it was like 8 o'clock in the 8 o'clock in the evening. So. So those searches, that was a lot. I remember, again, we were watching that while it was going on, and we were like, he's got that wrong. And then we watched it and rewatched, and I was like, he's got that wrong.
It wasn't bad.
Okay. So apparently Devin's sentencing wasn't that bad. He's coming home. Oh my God, I've been secure. Wow. So we've been following Devin Perkins, and apparently his sentencing wasn't that bad. Let's see. All right, so we'll get back to that. Devin Perkins was, we've had his mother on a couple times, Victoria. He was driving home from Orlando with his girlfriend, Alexandra, or Allie Spice. She was huge on TikTok. She had like 1 million followers. And he had 2 friends in his back seat, and the guy was coming at him 60 miles an hour, drunk, was drinking for like 6 hours, driving without lights on, coming at Devin, no lights on, slams into him, kills Allie Spice, kills the 2 kids in the back. Devin's mashed up. The guy who hit him runs away from the scene of the accident. He's got somebody in his as a passenger. They finally catch, well, that guy gets caught. So then the state went after, that guy took a plea deal, got, I think, 30 years. And then Devin got wrapped up in all this, and they were accusing him because he was going 100, well, they say he was going 100 miles an hour. He wasn't. He was going like 80 or 85. They got him wrapped up, and they wanted to put him away for like life or something like that. But apparently he, sentenced to 202 days in jail. Good for him. That could have been a lot worse. That could have been a lot worse. So anyway, that so the father, we had the father of Alexandra was on talking with us about that, Jimmy Doolin, and they didn't want Devin to go through this. They wanted him to come home too, so good for him. So he was sentenced to 364 days in jail, but he's received credit for 162 days. Yep. That's big. That's huge. So, all right, back to Todd. Yes, we do need to get them back. I've reached out to Victoria, seeing if she wants to come on or not. All right. Can't drive for 10 years. Yeah, hey, he'll take that. He'll take that. Yeah, Curviel, I'm sure Victoria is very, very, very relieved. Yeah. So. So anyway, why is that a good thing if he was driving drunk? He wasn't, Little Miss. He wasn't drunk. It was the guy that was driving towards him. The guy that was driving towards him was drinking for like 6 hours. Devin was not drunk. He had a BAC of 0.03, I think, and 0.08 is that's the limit, and I think 0.05 is you're not even considered an issue. So the state got it wrong to even accuse him, but it's good news. Oh, and the guy, Petri was his name. He wants to take back his plea deal. Believe that. All right, so looks like they're back here. We've got the only chair. We have only clock, only fan, and now only chair. Yeah, Little Miss. He wasn't drunk. They say he was going 100 miles an hour, but his black box of his car showed he hit the brakes, did a 15, I think, or 30-degree turn to get out of the way, and I think, yes, the speed limit, I think, was 70, and he was going like 85, maybe 90, right? So he was speeding, but the state was saying it was as much his fault as the guy coming at him at 2 o'clock in the morning without lights on. And, and the 3 other people had called 911 before that. This guy almost hit another person. He almost hit 3 other people called 911, and 911 didn't do anything. They didn't send anybody out to investigate. Oh, there's somebody driving on the wrong side of the road. So, Little Miss, check it out. Jules Investigates. We had on Victoria by herself with Jules, and then we had Victoria on with Jimmy Doolin, who was Allie Spice. Alexandra was her name. Allie Spice is her father. I'm sorry. we had on Allie Spice's dad, Jimmy Doolin. So, go check it out. Yep, money. Yep, family had to put out money for an attorney, and the appeals too. They did an appeal at the end of January, and because basically the defense brought in issues that they shouldn't have. He had some THC in his system. He admitted, which they never had brought in. So even his THC level was non-existent, But they brought that in, and of course the jury took like 20 minutes. And it was ridiculous. The jury took like 20 minutes to deliberate. It was a joke. They came back guilty, and it was like just a joke all the way around. But go check out those videos. It's under Jules Investigates. Victoria and Jules Investigates. If you guys are interested, go check those out. So. Hola, I almost got hit by a wrong side driver. I had nowhere to swerve. It was so frightening, but he swerved at last minute, but we were only going about 30. Yeah. Well, we'll see. We'll see what comes out of it, Little Miss. We'll see what comes out of it. Don't know anything about that yet. I remember when I was a kid, we were going to a drive-in, right? My family and my dad was driving, and I remember, I was a kid. I was like maybe 5. And I think we went to go see like Herbie the Love Bug or whatever, something like that. And I remember because I was usually in the back, right? Because I was the youngest, I was usually way in the back of the station wagon, the family truckster. And I remember some kind of commotion or whatever, and I looked up whatever. I remember, and my dad was saying, "Oh yeah, it's a drunk driver." And I remember this car was just like doing this, coming at us. But it was so far in it was like at least maybe a half a mile to a mile. My dad just pulled over, and guy drove by. Or maybe he pulled into somebody's driveway. But I remember that. That was like my first experience, if you will, with a drunk driver. But all the times that I've been driving, I don't think I've seen people swerve in front of me. And I've seen that often, unfortunately. I've seen that a lot, where people kind of drift off the road or whatever. I've never seen anybody like actually crash, or I never had anybody coming at me. So, knock on wood. Yeah, Baca, don't forget Devin was in the hospital. He was messed up. He was messed up himself. And this guy Petri left the scene of a crime, scene of a homicide, vehicular homicide, manslaughter, whatever you want to call it. And he left. He split. So he left his passenger, he left Devin, and then he left three kids, people, kids in their 20s. So, yeah, Kathy, I can't believe they brought charges against him at all. That's what everybody thought. But the end result is he's coming home. He might get some good behavior as well. So maybe he'll be home, let's see, what are we in March? April, May, June, 30, 60, 90, June, July. Yeah, he may be home by like July or August. That would be great. Brat says, I've driven in the UK, Ireland, Australia, and New Zealand. The wrong side thing was okay, but the car we had in New Zealand had the blinkers and windshield wipers on the wrong side, which got me every time. I can imagine, right? You go into turn and you hit the wipers instead of the turn signal. I did have a chance to drive in the UK. That was fun. That was fun. Crazy, but fun. And Italy. I drove in Italy as well, but that was not wrong. That was on the right side of the road, I think. Yeah, pretty sure. No, Brat, have you ever not been cranky? Yeah, and I'm just as shocked as you are. That's funny. Holly saying, Johnny's garlic spread is a must for my family. I'll need it. Sounds good. I like garlic. I love garlic and butter. So 4:05. She is late. She's usually been, this judge has usually been on, what's her name, Laura Parrish? Judge Laura Parrish. She's usually been pretty solid with being on time. All right, so as soon as they're done here, we're going to go over to Monica Cementilli. So we'll definitely catch up with Monica. That makes me feel good. Oh, yep, Todd's coming back into the, Todd's coming back. Butternut squash with garlicky butter sauce. Yep, that sounds good. Yeah, butternut squash therapist, it's sweet. You bake it, scoop it out. It's almost like a sweet potato, kind of. I mean, that's as close as I can think of. It's sort of, it's got a nutty, sweet potato-y kind of taste. That's the closest I can think of what it tastes like. New Zealand is heaven on earth. I'm planning to as well within the next few years. Thank you, therapist. Appreciate it. Are we about to get the answer we've been waiting on? All right, here we go. We'll see you on the other side.
Please be seated. Okay, we'll go back on the record. Ms. Thompson, you ready to proceed?
Thank you, Your Honor. Your Honor, Todd Mullis has spoken the truth in this case from day one. He said this was an accident. He asked his attorneys to investigate it as an accident. He gave multiple consistent interviews. He testified at trial. He testified at child guardianship proceedings that are part of the record below from his motion for a new trial. He filed this PCR, a verified PCR. He provided affidavits. His belief has been consistent and has never wavered that this is an accident, that he was in no way involved, and that he wanted his counsel to pursue that issue for him. That's different from other witnesses who testified at this proceeding and whose stories have changed over time. There's nothing that Todd Mullis could have said to this court that he hasn't said before. And that's why this post-conviction hearing has been about all of the evidence that should have been presented at trial to support what he's been saying all along. The court has pointed out that this is an evidentiary hearing, that all of the evidence this court is going to consider is not evidence this court heard in court during the last 6 days. Because as we just went through, the court will have depositions, the court will have documentary evidence, the court will have other evidence from the underlying record that wasn't part of what the court heard.
specifically in testimony and at this hearing. But all of that together demonstrates that Todd Mullis's trial was fundamentally unfair, that the system broke down, that he did not receive the fair trial that he deserves. And that is the outcome that Mr. Mullis is asking this court to assist with now. This court really can't think about what Mr. Mullis's claims mean without thinking about what it is that actually happened at his trial. What happened at his trial was that everyone, his own counsel, the state, told this jury that Ms. Mullis's death was a murder. His own counsel agreed in opening statements that Ms. Mullis was murdered, and that belief was allowed to be presented to the jury with zero adversarial testing. I mean, this was the quote-unquote strategy that his counsel pursued at trial. Their strategy was, we're going to concede it's a murder. That's a strategy they reached on the fly, which we'll talk about in a second. And as Mr. Firehelm told this court when he testified here, Todd's going to explain it. Todd will explain all of the evidence, and that is the way that they provided counsel to him through this trial. Their strategy was, Todd is going to explain the text messages. Todd is going to explain whether he knew about Ms. Mullis's affair with Mr. Frazier. Todd is going to explain the Google searches. Todd is going to explain the state of his marriage. Todd is going to explain what was happening in this argument between his wife and his mother. Todd's going to explain these hearsay statements from these witnesses. Todd is going to explain, without any notice or understanding that he even needed to prepare to think about or testify about this 911 call and what he said and who was there and what he was thinking when he was frantically providing aid to his wife as she was dying. Todd's going to explain the state's circumstantial evidence that is meant to show that he was guilty. And that in effect became a trial where counsel is telling the jury, even though I told you in opening statements that Todd was wrong, believe him that he's not guilty. That is not a reasonable strategy. It's simply not a reasonable strategy, and it and all of the errors that combined cumulatively to deny him a fair trial, denied him a fair trial. There are two Sixth Amendment claims that Mr. Mullis has in this case, and they're different. We talked about these at summary judgment, but I want to talk briefly about them now. One is the Sixth Amendment claim that Todd has the right to be the master of his own defense, and we spent a lot of time on that claim at this hearing, hearing from various witnesses, and I know the court has the law on this that we provided at summary judgment. The law is that Mr. Mullis has to explicitly consent in opening statements, or has to explicitly consent to his counsel conceding his guilt in the trial. He has to explicitly consent if that's the strategy. And from all of the testimony the court heard, from Mr. Firehelm, from Mr. Sabers' deposition that the court will read, from all of Todd's letters and his testimony at the child guardianship proceedings that are in the record, that simply never happened. This resulted in a situation where his trial counsel conceded his guilt because he told the jury that Amy Mullis was murdered in a situation where the lawyers were going to provide no evidence to establish that that was not Todd Mullis. The evidence is undisputed that Todd Mullis didn't know his counsel was going to do that. The court has Mr. Sabers' deposition, who testified at a deposition, and the court can review this, that he was surprised at opening statements. He was surprised to hear that that was the position the defense was going to take, that Mr. Mullis was surprised. The court has all of his letters. The court has heard from Lynn White. The court will be able to review Todd's testimony in these child custody proceedings. Todd said he never gave counsel permission to do that. All of his letters support that that's not what he understood the strategy was going to be. Mr. Sabers didn't know that was going to be the strategy. That happened without his permission. And we explained already why that's important, because if that happened without his permission, then this isn't a matter of prejudice. It's not a matter of establishing what the outcome would have been if counsel followed a different strategy. That is just a Sixth Amendment violation, period. That really ends the analysis. And on that basis alone, Mr. Mullis receives a new trial. But that's not the only aspect of Sixth Amendment. That's not the only aspect of a Sixth Amendment violation that is present here. We have a more typical ineffective assistance of counsel claim too. And this is very important because in this case, the state In this case, there is no reason, and the court heard no reason from Mr. Firehelm, there is no reason in Mr. Sabers' deposition to explain why it would have been reasonable for trial counsel not to investigate and present evidence that corroborated everything that Mr. Mullis testified to at trial. To investigate and present evidence about medicine, about the electronic evidence, about these Google searches that we've been talking about text messages, about the cameras. There is no reasonable strategy that would have allowed counsel to not pursue any of this evidence, and instead to pursue what they did at trial, which is to concede this was a murder and to let Todd explain himself unaided to the jury. What's important about this, and what we want to make sure the court understands, is that even though in this evidentiary hearing the applicant has spent a lot of time presenting evidence to the court and proving to the court that Mr. Mullis didn't agree with counsel's strategy, even if Todd Mullis never wrote a single letter to his lawyer, even if he was maybe a person with a little less understanding about the way that biomechanics work, his instincts about what might be true. Even if we had none of these letters, even if we didn't have the vast record we have here that Mr. Mullis was asking about these issues, that he wanted this to be investigated, that he was seeking investigation, that he consistently and unwaveringly believed that his wife's death was an accident, even if none of that was true, and Todd Mullis had just said to his lawyers, give me the best defense you can, I don't know what happened, but do your best. If that's all he ever said, counsel would have still been ineffective. It is not Todd Mullis' job to have told counsel what the right strategy was here. As it so happens, he did. But even if he didn't, it doesn't matter, because there's no reason not to investigate these issues. This is not dependent on what Todd Mullis agreed to or not. It is ineffective for counsel to have chosen the path that they chose, and that is because they chose it without a reasonable investigation. We cited law to the court in our summary judgment briefings, and we will cite more law. The United States versus Hinton, the United States Supreme Court has said that it is ineffective for counsel not to understand science and not to get experts in a case where expertise is required. And Your Honor, this is such a case. This was clearly a medical case. Mr. Firehelm told you, I relied on my own understanding about this. You know, I was first chair, I made these decisions. I relied on my own understanding to decide that there wasn't anything I needed to pursue there. Under Hinton, under the other law that we've cited to the court and that we will cite, that's ineffective. The state may point out when it speaks to the court that in his deposition, Mr. Sabers did describe, as the second chair, as the person who was not making decisions in this case, some of the things that he tried to do, because he did try to do more than Mr. Firehelm did. For instance, he himself went to the shed. He looked at these augers, and he talked about that in his deposition. He also read the case materials, like Mr. Firehelm did. But there's no evidence that Mr. Sabers discussed these issues with Mr. Firehelm other than telling him that he'd visited the shed and looked at these augers. And there's no evidence that Mr. Firehelm did anything that Mr. Sabers asked him to do. The state's own exhibits show this, that there is a email from Mr. Sabers to Mr. Firehelm where they discuss we probably should get an expert. I mean, they knew that Todd was asking them to do that. They agreed they probably should get an expert, and that just didn't happen here. They never provided case materials to an expert, either a pathologist or a biomechanical expert, who could explain to them that there was a defense here, a reasonable defense that they should have followed. They just didn't do that. And Mr. Sabers, doing his best to look at a couple of things, to give advice to Mr. Firehelm that he never followed, that's not a strategy, that's not a decision, that's failing to do what you know you should do. And there's no reason that the state is going to be able to articulate for not following the only reasonable strategy here. That leaves us with the question of what this trial would have been, the prejudice issue of Strickland, if Todd Mullis hadn't been standing alone at his trial without any of the assistance that his counsel was supposed to provide him. If his lawyer wasn't just saying, trust Todd, what would the jury have heard? And at the end of this hearing, especially hearing the evidence the court's heard here in court, considering the other materials as well, the court knows the answer to that. The court knows that if this had been a fair trial with effective assistance, this jury would have heard that this was not a murder. And it would have heard that from sources that are far more credible than the state's witness who testified at trial without any cross-examination, save one question, that this was a murder. This was a medical case. And the court heard extensively, and I know we spent a lot of the court's time making sure that the court could hear the opinions of Dr. Cruz, the opinions of Dr. Hammers, the opinions of Dr. Nye, to decide what the true state of the medicine is. And based on that testimony, there's really no question what the state of the medicine is. This is not a murder. This is not a homicide. This is an accident. Dr. Hammers was able to talk about that from a pathology perspective and explain why, despite there being unopposed testimony offered at trial that Ms. Mullis had defensive wounds, that there was nothing about the state of her body or this autopsy that indicated that she was the victim of a homicide, but that this was an accident from a pathology perspective. The court knows that Dr. Cruz said that she couldn't really figure out how this happened. She just couldn't see any reason that it was an accident, and that is essentially why she determined this was a murder. After 2 to 3 hours of doing this autopsy with other autopsies, she came to that decision, she stuck with it, and she made that decision without the benefit of any biomechanical testimony, any biomechanical advice or assistance. The court has that assistance now from Dr. Nye. Dr. Nye started looking at this case to review the opinions of others, and we're not asking the court to even consider that piece of what she did, because she then went on to do her own investigation. She did her own visit to this scene. She did her own consideration of the wound pattern. She did her own force calculations. The court has her math on her notes where she went through and actually figured this out, figured out the force that would have been required to fall from a standing height, from a kneeling height, figured out the force that would have been required and the direction of the force that would have been required for this to have happened in different ways. And from that biomechanical evaluation, she told the court that the only hypothesis that she can't disprove is that this was an accident. And there is no other biomechanical evidence before this court. If the state wanted to call a biomechanical engineer, or really any witness, to say that Dr. Nye was wrong, they could have done that. That's not what they did. Dr. Nye testified without any opposition. Dr. Cruz said, I really can't speak to those issues. And that's testimony the court has to consider in deciding what the state of the evidence is here. I'll go through the other evidence the court heard briefly, because the medical evidence is the most important. The court heard that despite at trial the unrebutted testimony, save from Mr. Mullis, was that all these searches were from the iPad and that they were very nefarious. And when the court actually gets a chance to see that those searches didn't come from the iPad, that many of them came from other devices, and the actual content of the search, that these searches are related to hunting tests, they're related to television programs. The actual content of the searches and the evidence that they didn't come from the iPad tells you that Todd's testimony was right. The court will have a chance to look at all of these texts and emails which are in evidence, and the court heard from Mr. Saffre and others about what all of this electronic evidence means. And it proves what Todd said, which is that even though his wife was having an affair, this had not bled over into the marriage, that he didn't know about it, that they were living relatively happily, despite the fact that there were sometimes, disputes with a mother-in-law. None of this was creating this situation that resulted in some planning to end someone's wife's life. I mean, there are text messages with Todd right up until the end of Miss Mullis's life where she's saying, I love you. The court has Tristan's testimony, and it should evaluate it, that Tristan has explained why he testified as he did, and that his dad was really only out of his sight for a short time. The court knows about the 911 call. It heard a lot about that, about the discovery violation that occurred there, and that this was a trial by ambush with respect to this 911 call, and that 911 call is not what the state described, and that Todd was with other people, sheriffs, when that happened. There's a lot of other claims that counsel presented, and the court knows what the evidence about that is. Based on the evidence the court has, it knows that Todd's established his Sixth Amendment claims, it knows he's established an actual innocence claim, and that this is the rare case where, considering these claims separately or cumulatively, that a new trial is really the only fair outcome. I'm going to come back and talk in rebuttal in a minute, but based on what the court's heard, there's no doubt that Mr. Mullis's trial was unfair, and there's just one result from that, Your Honor, which is a new trial.
Thank you, Ms. Thompson. Closing argument on behalf of the state.
Thank you, Your Honor, and may it please the court. Good afternoon. I will be brief. The state submits that Mr. Mullis has not met his burden of proof on any of his claims. We ask the court to deny his application in its entirety. In addition to the record and issues that have already been developed at trial and before it in this proceeding, we will address our legal reasoning for why each of his claims fail in our written brief. Thank you.
Thank you, counsel. Your final rebuttal.
I just want to add one more thing, which is that although we believe that we've established Mr. Mullis's actual innocence, which means that there should not be any new trial, if the state concludes that they want to rely on Dr. Cruz and retry him, that's an opportunity that he should have an opportunity to present this evidence to the jury. Because the last thing I'll say about this is the court may conclude in looking at all of the evidence, both what it heard here, what it reads in the record, and it may determine, well, I see some evidence on the other side. You know, I see some evidence still that for me, I don't know what to make of that. I see that the state made some arguments at the original trial, and for me, I don't know where I end up on actual innocence. The court can have questions as a result of this hearing about what happened, but as the court knows, those questions are the province of the jury. It is for the jury to decide if it believes Mr. Mullis. It's for the jury to decide if it believes this other evidence. But this is all evidence that the jury should hear. Because Mr. Mullis has established there is at least a reasonable likelihood that the outcome of this trial would have been different, with the overwhelming evidence that the court has seen, that it has read and will read, that it's heard. This is evidence of an innocent man. This is evidence of a man that deserves a new trial, and a trial where he can have his day in court. And for that reason, Your Honor, we're asking the court to grant Mr. Mullis a new trial, and we'll provide additional legal briefing in the post-trial briefing that we make in a month, Your Honor. Thank you.
Thank you, counsel. I will await both parties' final briefing by the April date that we previously discussed. At that point, I will consider the matter finally submitted. Counsel, if you maybe just want to touch base with me briefly in chambers before you leave so that we can make sure that everybody is on the same page as far as the exhibits that were admitted. And then I'll give you a day or two just to review any final security level issues before I file the exhibit management order. Other than that, anything that we need to address before we go off the record? Anything on behalf of the applicant?
No, Your Honor.
Okay. Anything on behalf of the state?
No, Your Honor.
All right. Thank you all for appearing and for your cooperation to keep things moving throughout the trial these past days. Thank you.
All right, so that concludes Todd Mullis's post-conviction relief hearing. So, and no, the original judge did not come into this one. I saw somebody just ask that question. I forget who that was. Sorry. The original judge was Judge Thomas Biter, B-I-T-T-E-R. Judge Baca. You asked that. Was the original judge not available for this? We didn't see him, nor did we see the original prosecution, Denise Timmons or John Bernau. Didn't see them at all. So, hola, I missed when are we likely to hear the judge's decision? I think April 8th. Well, wait, the deadline is April 8th, and then we're not quite sure how long it will take her. So we'll cover it, we'll follow it. So the defense closing was pretty much what we've heard the whole time. There was really nothing new in there. Other than she said the state did not call in a biomechanical expert to refute what Dr. Nagai said. So kind of thought that was interesting. And it's a wrap. Bop. Yep. So that's that. All right. So let's see. So our two polls were, should Todd receive a new trial? 61% said yes, 38% said no, so that's should he. And then will he? 56% said yes, 44% said no. So slightly more wanted him to receive a new trial. Now hold on a sec. We took another poll. Okay, so after his first attorney's testimony, On day 4, Mr. Firehelm, we did a poll with Mr. Firehelm's testimony. Where do you land now? 75% of you said Todd needs a new trial. 15% said not enough evidence for a new trial, and 9% said need to see more evidence. So on day 4, 75% of you thought he needed a new trial, and he was going to get one, wanted one, and then 61% after on day 6 now. So Ola. So April 8th is the deadline. Maybe April, May. Maybe it'll take her just a couple weeks. Hopefully. Maybe we'll hear by May. So, all right. Hey, fun's not over yet. We're going to go over to Monica Cementili. We're going to catch up from Friday's stream, day 20. And we have surprises for you because we know somebody's going to testify. So somebody testified Friday, and it's you're definitely going to want to watch that. So we are going to start that 5 o'clock. Stream is at 5 o'clock. Let me see here for a second. Let me just real quick here. All right, hold on.
To publish at this time?
Yes.
All right. Trial Junkies United, objection. It better be good because I'm so over Monica's trial. I'm afraid it is a new YSL. Yeah, we saw who's testifying, and also I did a peek today. It's interesting. It's interesting. That's all I'm going to say. Baka, I didn't watch ahead. I had to take a little peek to see what's going on. But Austin's supposed to be testifying soon, maybe. And I think, hey Mona, I think you said you were going to be there this week. So, all right, guys, I am going to let you go for now. Thank you for joining us for the Todd Mullis, Iowa versus Todd Mullis post-conviction relief hearing. Thank you to Aaron. Thank you to OnlyFan, Therapist You Know. Thank you to Fala, Widespread Panic, Hellcat. Thank you to Brat, Florida PI Sam. Thank you for being in our be part of our mod squad today. Rachel B, I think you were the only one, and Jules. If you guys were in the chat, I'm sorry if I missed you guys, but thank you to our mods. Thank you, everybody that watched the Todd Mullis with us. Please join us over at Monica Cementili. Day 20. We're catching up on Friday's testimony. So we're going to go over there, and we have some really good things in the works for you guys. We've got possibly... we got some good things in the works for some interviews, for some really interesting things. I can't say yet because we have to secure the people that are going to be interviewed. But suffice it to say, we've got some really good things lined up, and I'm hoping they come through because you guys are your minds are gonna be blown. All right. Make sure your seats and trays are in the upright position. We will jettison you over to, portal you over to Monica Cementili. Thanks for watching again, and we will see you in a little bit. Bye.